ఎవరు ఫోటో ఆఫీస్ तेरे पर्स में है ना प्रोविजन 17 18 के लिए तो 18 को नहीं 18 नहीं है सर्विस मैटर ना नहीं पिटिशंस 15 नहीं मेगा पिटिशंस ऐसा पिटिशन 17 पिटिशन कभी भी वेकेट करते हो तो आ जाता 15 के कभी भी आता पिटिशन डब्ल्यूपी 17 के ओके ओके 15 का है तो 17 है डब्ल्यूपीटी 2017 भी है ओके अब सेकंड पीस का कुछ भी है वेकेट का मैं 2022 में डाला 17 में ना 15 का 15 रिपिटिशन है तुम्हें वेकेट है को नहीं है ना सर 15 को ये 15 कार्तिक सर को हां कार्तिक खुला का सर्विस मैटर है ना सर्विस नहीं है हां नहीं इसका नहीं है देख लेंगे बार पर देखो जनता को मालूम हो तो वहां भाग सकते हैं उसको कौन सा भाग में revenue up to the year 2019 into producer interrupter but into check restrictions service rate into revenue sir చెప్పండి అంది వేలో ఉంటాయి కోట్ చెప్పండి ఓకే ఓకే సర్ పర్వాలేదు స్టార్టింగ్ కౌన్సిల్ కలిసారంటారు కదా ఏమి ఇచ్చారు ఆయనకు ఆయన ఇచ్చుకుంటా అన్నాడా ఓకే పర్వాలేదు సరే సార్ ఇదే రైట్ 10-15 days పడుతుంది దాన్ని ఫైనల్ ఆర్డర్ కదా రావడానికి कल परसों नए लोगों को कुछ लिस्ट किया है नहीं करता मैं नवंबर में चले नहीं करता बोला नहीं करता नवंबर दिसंबर फर्स्ट वीक में चले आता मेरे कई को सड़ पड़ी फिर वो बोले बाद और एक बार सुन तब इसमें प्रवीण और कुमार स्पेशल जीपी वो लोगों के नाम कंसिडरेशन में है हाँ वो बोल रहे थे उसके वास्ते पूछना मैं भी सुना तो भी सुना ऐसा भी हुआ सर कुमार और प्रवीण गाड़ी प्रवीण हाँ उनको होता कैसा इसी में है ना हरिनाथ बन गए देखो आंध्र प्रदेश हाई कोर्ट।
हाँ हरनाथ साहब बागा एसी था ना वो?
गवर्नमेंट मेरा उसका
अच्छा आदमी है साहब,
के सुरेंद्र साहब का
बहुत फ्री माइंड रहता है,
बहुत अच्छा आदमी।
लिबरल आदमी।
हाँ मुझे प्रैक्टिस करते हैं यहाँ पे स्टार्टिंग में
वापस करने की कोशिश करते
वो ऊपर क्या है वो तो अपनी को उसका
इसके लिए पॉलिटिक्स रहता सब,
पॉलिटिक्स रहता
वो कहाँ फिर लेते बैठे ना, है होता फिर ना।
हाँ फिरना कहाँ से होता वो क्रिकेट के तान हो जाना बोलते लोग बोलते उनको मिलो इनको पाँच होता अगला वाला बोल के प्रैक्टिस कर रहे तो
बस ऐसा सही बात है, टेंशन नहीं, टेंशन से रहते साहब।
हाँ हाँ अगला चाहे तो जो है कहीं भी बैठे तो अपने को आ जाता।
जी जी
हाँ पैसा मेरा ये है इसमें। Mentioning उसका है स्टार है ना
తల్లి తెలంగాణ కేసీఆర్ గారు
హలో
frankly speaking पूरा
హలో
तो अच्छा देता आज तक उन्होंने आज उसके घर में 4 लोग हैं, उसकी बीवी जेडपीटी से, उसका बेटा क्या है कि एमपीटी से।
पॉलिटिकल एम्प्लॉयज
4 लोग हैं,
पॉलिटिकल एम्प्लॉयज
तो पूछे क्या होता है, कैसे रन करेगा
ओके टीआरएस कैसे है
टीआरएस का?
अभी
कांग्रेस में था,
अभी आता
अभी थोड़ा डाउट है कि रत्न को दिया ना, वो स्प्लिट करता हो कांग्रेस का है
तब इसको दिए टिकट
ये तो लोग हैं, उसको दिया ना, मतलब तो
पहले का लोग
पहले को लोग 800-900 करोड़ कुछ भी नहीं था, बचपन में देखते थे उसको, वो चर्चे जिनके आता था लड़के था मगर एक चीज मैं गौर करा, वो लेवल पे स्टूट डाउन नहीं कर सकता।
नहीं स्वाभाविक बात है अब आप है खानदानी आदमी स्टैंडर्ड होता आपका पैसा लो मत करो स्टैंडर्ड की बात कर सकते ये लोग ना अपनी असालत भूल जाते हैं ना 150
Yes.
Page-wise mentionings. Item 1 to 11.
Controversial trend that which has become infectious. Definitely. What else? And that means
May also become they are another.
your name?
Maharashtra.
इधर बच्चा सुनो आपके पास चले ना ये रास्ता नंबर 6 अरे आइटम 6 आता नहीं है सच्चे साइड तुम्हारा पेरेंट हाँ आता नेम पे व्हाट इज नेम ये पे Depend that representing the journal. Depend that the representation between pictures. This is an infectious. Yes. Yes. Why?
Regarding pension case, whether they are released pension benefits. No, right, okay.
I don't know. Fine tomorrow. Or you can have Saturday. Number 6.
Number
Wait, wait,
item 6 మీరు మెన్షన్ చేశారు సార్. Item 6 మీ పేరు
your own council. 5 tomorrow or Saturday also we are working day. Every Saturday is there. Item 5
By tomorrow or next week.
tomorrow. Please request a council question for tomorrow. To verify the pension benefits and leaves or not. Yes.
Item 12 to 24. Item 25 to 39.
26 last.
Item 9 million.
Item
Item 9 requesting 5 million.
tell me. Yes.
Item number 9. I am G. Rajesh Council.
Yes, yes, tell me.
Next week million.
Why?
No, 27 acts the petitioner member.
Next week.
The last occasion
Item
is
9.
directed to the
One second, wait. What is item 9? Where is seeking for time? What is it here?
Is the petition
Item number 9 million. Yes. Item number 9 and 24 requesting 5 million.
What for? What is the problem?
Item number 9. In the item number 9, they have not filed counter millet and they are not served the counter.
Counter file?
yes, ma'am. Counter file and
Counter file long back, not filed a very long back.
No millet. Yes, they filed yesterday and not served counter also.
I will give you one more copy.
The standing council through Srinivas is here. He said he will serve copy. Take copy and then get ready.
No, not served millet.
He said he will serve today.
Next week millet.
18 11th.
Yes. Item 24 also millet.
Yes, yes. Both are 18 11.
Yes. Why?
Serve copy is Srinivas. Serve copy and yes.
Item 25 to 39.
Yes.
Right. For the petitioner Millard, in fact, this matter pertains to promotion Millard. In fact, government has also issued a memo to consider the case of the petitioner Millard. On the last occasion, the council took time for inspection.
When next week? 2070 matters will take because
Memo is already issued.
you always busy. Only you need to chase them. Otherwise, pass the order and then let him come like that. Or unnecessarily in the
Next week. In fact, Lordship can dispose of Millard because
wait for 1 week. 2070 matters. Why you unnecessarily want next week?
any date
18 11.
published.
18 11. Services 3. Your services 2 or 3? 3. Services 3. The request of service 3. Post 18 11. Yes. Next.
Item 40 to 58.
Petitioner, previous certificate, guidance, file what are the 18th of
18 11. Item 47. Your name? Your good name?
Venkat Raghumandan.
Fine. But last time you already filed Wakala.
Yes, I filed Wakala. I want to
The council petitioner replied that they filed Wakala recently.
1811.
That's fine. Accordingly, posted 18 11. Count has been filed in this?
Yes, yes, counter file.
Get ready. All these matters get ready. Saturday will finish. Yes.
Much work.
Item 59 to 79. Item 80 to 85. out of list mentions. Item 1, V. Brahme Chaudhary, G. Dhananjay.
Item 2 is done.
192.
R1 is trial option.
You filed an application for,
Petition is filed. Sanlam is record option.
no. Contents are,
Last urgent notices are
whether served or not, where is it?
not there. Notices sent not yet written option.
How do you explain 2,417 days delay? You're not aware?
Respondent filed a death certificate pending 21/9/23.
This matter I am referring for the respondents might be the area. Blood parties are not contacted with this. They were not contacted the parties. That is the reason we requested last occasion to serve the notice to the proposed LRs Miller. Lordship may ordered the.
No, they already taken. You have you sent the notices?
Yes, Lord.
The list showing the not yet returned.
Not yet.
Please remove all the caption.
Item 1. Cost was imposed. Kind of his cost was imposed. Why it was imposed? 13,922 cost.
First number is filed option. Register number is 879.
Correct. Why cost was imposed?
Hospital imposition.
Okay. Next.
Item 3, MVDS Narasimha Hardik, D. Jayapal Reddy.
Petition to discover additional petition.
Respondent.
Waiting for defendant.
So they filed an application. You got the copy? You not some copy? You want to file a document at the appellate stage now?
Already the documents are filed in second appeal also, my lord.
No, they say that these are for subsequent development. You file a count.
Yes, my lord, it's a problem.
Copy, you have got the copy. When? Adjustment is there. $18.11. How much time you require? Whether you want to file counter. Counter is not there on it. For this IA on it. On the IA. Counter is not there in the front. It was filed on 6/11. After that, it has come on. Counter is not there. Counter against IA. Don't have any counter. Without knowing, you are saying the counter has been filed. First you said you didn't have copy, then you are saying that the counter has been filed. I have confirmed on the facts and then we will. Post on 3011.
For B Subhash, GP for home, maybe Ramarao.
Please, Your Honor. In compliance with directions of this honorable court, 3/11/2023, served the papers once again to the chief by SR number 7386 of 24/11/2023. Number 08506 of 23 dated 3/11.
Yes.
This is the case of the petition you are asking. Even after honorably observing from the TDP proceedings, the respondents repeated his suspension period as not on duty. But page number 42A6 is the impugned memo.
Page number
46.
yes.
The Director General of Police, Andhra Pradesh, Hyderabad is informed that reference code cited Sri D. Nageshwara, Inspector of Police, GTC Churchanda, Mahabubnagar, formerly Sub Inspector of Police, formerly Pedavara Police Station, Nalgonda District, has submitted a review petition requesting for regularization of his suspension period as not on duty. Government, after careful examination of the review petition and entire matter, hereby reject the request of the individual since there was adequate justification for placing him under suspension.
Yes.
So, Your Lordship, this order is also contrary to the judgment of Honorable Supreme Court of India in case of Niharika Infrastructure versus State of Maharashtra, wherein the Honorable Supreme Court, reiterating its earlier judgment, has held that the administrative authorities should also record judicially acceptable reasons in their orders. Your Lordship, now coming to the GO RT number 553, dated 2/4/2021, Your Lordship, page number 37 to 38. Page number 38, Your Lordship, para number 7 of the operating. Government, after careful examination of the entire matter and taking into consideration of the explanation submitted by the charged officer D. Nageshwara, Sub Inspector of Police, formerly at Pedavara, Nalgonda District, hereby decided and ordered to drop further action against D. Nageshwara, Sub Inspector of Police, formerly at Pedavara Police, Nalgonda District, on the allegation of corruption and the allegation of non-submission of annual property returns to the competent authority, duly exonerating him from the charges since the charges were held not proved by the tribunal for discipline. Your Lordship, as per their own order, the petitioner is honorably absolved of the charges. No charges of corruption as well as non-filing of APRs were held proved by the tribunal for disciplinary questions. But in a very strange manner, Your Lordship, they have rejected the representation of the petitioner,
Yes.
wherein he sought for regularization of suspension. Lordship, this regard, the Honorable High Court judgment upon this judgment, Your Lordship, and it's fairly covered matter. Very recently. Page number 27 and para number 20. The court opens that in similar circumstances, orders have been passed over GORT number 1238. 27.
Yeah.
This court opens that in similar circumstances, orders have been passed over GORT number 1238 dated 18/5/23 and by GORT number 1268 dated 22/5/23. Stating the period of suspension listed cases as on duty under fundamental rules 54B4 by the third respondent herein. However, no relief has been given to the petitioner herein. Though the government has set aside the punishment of PPA for 1 year with effect imposed against the petitioner by GORT number 1670 dated 13/9/2012 under 54B. Government, however, admitted as barred on record did not issue any notice to the petitioner, did not pass specific orders stating the period of suspension of the petitioner as a period spent on duty for all purposes as per 54B. For having extended the said benefit to similarly situated persons like the petitioner, the same has been denied to the petitioner for no rhyme or reason. But in my case, the charges are even much good. But in this judgment of the Honorable High Court, they allowed wherein the punishment was imposed and thereafter later it was set aside. Actually, kindly come to my expedition material, page number A11, page number 51 to 52. Page number 51 is the government order of the government, Your Lordship, in case of T. Murali Krishna, Sub Inspector of Police, Your Lordship, the operative portion, Your Lordship.
Yes.
Page number 52, Your Lordship. Page number 52.
Yes.
Para number 6, Your Lordship. Now, as regards to the suspension period against both the charged officers, government have further examined that matter, have decided and hereby ordered to treat the period of suspension in respect of T. Murali Krishna, Sub Inspector of Police, and C. M. Shamsundar, Police Constable 1902, formerly at Vendana Police Station, Mahabubnagar District, as on duty under FR 54B3. The similar GO is in page number 53, Your Lordship, in case of P. Ravikumar.
What is 54B? What it says?
54B says, Your Lordship, whenever the charges against the delinquent officer are dropped honorably, the suspension period has to be treated as on duty. So they have showing discrimination in respect of certain police officers by giving the benefit, whereas they are not giving the same benefit even after honorable observation of the charges by the petitioner. So I find page number 53 is one another GO, Your Lordship. Page number 54 is also see Gurunath Babu, Sub Inspector, at page number 55 is D. Ravikumar, similarly situated persons. Your Lordship. There are hundreds of persons like this. Your Lordship. Moreover, this is important. Your Lordship. Page number 57 is the Mr. Muhammad Fazlur Rahman, Sub Inspector of Police. Now he is working as OSD to the Home Minister. Your Lordship. There is a clear discrimination of application of section rule 54B by the respondents, Your Lordship. Moreover, in their counter also, they were nowhere mentioned about these GOs and action taken by the.
They are silent. They are completely silent on this.
Yes, Your Lordship. I have answered the same in my reply also. Your Lordship. My complete submission, Your Lordship, petitioner is entitled.
What is it?
I am told that counter is not silent.
Don't have control on this.
You respect to Your Lordship. Mislead this honorable court by taking undue.
They also filed reply. Counter has filed reply.
Counter is there, my reply is also there.
Counter there, reply is there, everything is there.
Sorry, also counter is not here.
No. Yes, verify. Reply also filed.
It is also there, Your Lordship. They are moving before the file. So going through the files.
You saw the copies on. You saw the copy that.
served, Your Honor. After
Yes,
serving
and
the
got the copy of the writ petition to that election. That's it.
Counter.
Lordships were passed over, Lordship. I submit my.
230. Nothing is there. In fact, see preview. Other.
Got the judgments also, Lordship of the Supreme Court.
What it says? The state can discriminate against same similar place with employees. Other employees, the number of employees who are in fact acquitted, all of them you have treated differently, and you have treated this person different, completely different.
Lordship should only pass you.
Yes. You go to this page 50, oh, 53, 57. Number of employees who are in fact exonerated and acquitted, they have been given. But the service was treated as continuous. But the suspension given. How can you discriminate with Krishna? Same set of cards, same set of circumstances. By the specific different treatment to the Krishna. Was file counter. Rajiv Trivedi. Doesn't say anything. The other contentions nowhere, in fact, not even referred to. Number of, in fact, if you read the counter, except repeating, nothing is stated about the treatment given to the other employees. Complete silence. Yeah. Also,
Item 7K Ramasubbarao, VP for Education Services.
Instruction from the work data, got to the proposal pending with the government. But the admitted counter. With 9 of the counter.
yes. The commissioner, in fact, he recommended government has to take a decision.
Everything is applied in the counter, but there is no payment travel for village officers working in the districts. Therefore, the commissioner has sent a proposal to the government for amendment of rules, which is pending with the government consideration.
Item 9.
Yes, yes. This is pending for the government.
Let them take a decision, let the correct and only. Tax on activity.
Yes. Take some time.
Still, you are taking time for getting instructions within status.
Can't help. The government has taken this one. Doesn't take decision. We are only.
At least the authority is the government. When they admitted that the tax rate, there is a proposal pending with the government.
So what is time?
3 months. The 1 month.
No objection. We are waiting for last 2 weeks for finding.
wherein an administrative test has to be passed by the petitioner as per GOMS number 304 for 8 hours.
Yes. Para 8 last, para 7 just, para 7 last 4 lines. Clearly said that no promotion channel is available.
7, 8, 9.
Stagnation is.
He also recommended for nothing, in fact, there is no dispute with regard to it. So only the government has to take a decision and then amend it.
Because they are
Second.
stated so options.
And see, because the second respond doesn't have authority, he in fact, are recommended for this. He also recommended.
This were also enclosed, that proposing the amendment. Those are enclosed, when the reference is there, just they have to approve, government has to approve, it's the.
He take his own seat type.
The clauses are already been expired. 2017 with petition, 2023 machine, they have taken it.
Hope for the best. Let us see. The Yes, yes.
I dispose of that.
Dispose. Dispose.
Item 10 and 11, Kiran Palakutti, R. Vinod Reddy, D. Balakrishnan Road.
But 10 is different from 11. 10 mallet can be stored in view of mallet here, they have prayed for mallet 10. Not considering that for promotion mallet that was later granted mallet. Now itself has stated para.
Senior assistant.
Yes, para 2. But you think that 30/11/2017 mallet was granted.
No, your counters are not doing.
All case for promotion mallet. Para 2 mallet last lecture.
Yes.
39, page 39, para 2.
Yes. What do you say?
That one more matter is there.
This covered this about this match.
But this can be disposed of. So this is view of the promotion only.
What about item 11?
Family post along with one more notification number that is posted on 29/11.
What is it?
Expedition number 314.
What is it?
Meanwhile, let them on the requirement after that, they have actually, the tests were held whether the petitioner participated in the, went for the test and passed. It was certain test
No,
promotion.
No, they're only saying that one particular year you are not conducted examination. They are supposed to get that account.
After that, I'll explain, I'll also.
Because see, in fact, they have got I think 9 years to pass the test.
Yes.
Only one particular year, 2016, you have not conducted. That they are taking as a ground that had they conducted one exam, you have passed. What about the other 8 years? Instructions. One particular year, you can't take that exception and saying that to blame the government. What else this comes? Yeah, council for Krishna. That's another connection matter. Post and 2011, requested this matter to also go along.
Item 12, K. Pallavi, GP Prospect, Revenue Services, Murli Krishna.
Why?
Done before the last.
The last time also there is no representation.
It's a case where, may I submit one thing? It's a case wherein the petitioner taking the temporary service, he pended for 1 year to qualify for the pension. It seems he have filed a representation also. Not received any instruction regarding they have passed any orders on the representation or not. 1 week may be given, only the instruction regarding
Counter not in the
last occasion, order is not filed.
case is only a question of you say yes or no, what will include.
I'll get it.
There's only one particular year.
1 week only.
Only 1 year. The request of council petitioner. We learn the critical consistency and opting system.
Balakrishnan Rao, GP for Services.
May please.
Yeah.
I am appearing on online lodgement can consider matter pertaining to recruitment to the post of language grade 2. Pursuant to the notification, it is squarely covered by the judgment of the Honorable Court, which was confirmed by the DGM of Supreme Court also. Last occasion, amendment prayer was allowed, and the government period directed to verify the judgment and inform the Honorable Court whether they covered or not. So far as the judgment of the Honorable Supreme Court concerned, you lost para 6, the judgment, along with IIFL.
I need copies and ask you to your lordship. May I take it up next week, any day, your lordship?
It's already covered. What is accounting is already covered. Supreme Court already said that even one
Single subject.
also has
Eligible.
eligible.
Paragraph 6 minutes in the judgment. Categorically held that minute they are entitled to be considered for appointment. Confirming the judgment of the judgment of the Honorable Court.
Same, in fact, appointment of post of line Pandit Telugu is own the same.
Same matter, similar matter.
Short, pass it over, your lordship. I'll go through once.
You have copy. You have copies or don't have copies.
That is lordship, may take it up tomorrow, your lordship. I'll complete the copy.
Mr. Balakrishnan is being posted tomorrow. You see
Might
what it appears doesn't have copy. He wants to go through and then report tomorrow.
Yes, my pleasure. In fact, it is covered by the judgment. Covered, fairly covered.
He wants to only go through. Let him in 1 day. Tomorrow.
Should permit me to take out copy.
Extra copy. Copy. Request of the people.
First.
Yes. Very close. Good morning, was it? No, not here. Notification for Krishna. Notice.
Item 15 and 16, Ravinder A. S. Vijay Prashant, D. Shivakumar, P. Krishnaya. Ready?
Next.
Item 17, Mohammed Shiraz.
May it please your lordship, and for item number 17, I may be permitted to withdraw the petition. This is the case of a senior surgeon in the veterinary department, where his scale was not being there, so he's under promotion now. So, client's instruction.
Item 17, first profession. Six permission to withdraw. Next.
Item 18 and 19, Ravi K. M.E. Ramarao, GP perform assignment services for mental.
Yes.
Petition is filed. Challenge the senior petitioner was appointed in the
Ready?
I need to certain instructions logic in the
Reply is also there. Counter is there. Reply is there. What is this further instructions? We already filed counter.
I have to ascertain latest instruction with regard to the content matter.
Content is already closed. Content is already closed. Content is already closed. Content closed on 27/8/2018 in the light of rejection of his application. On 28/2/2018, his application was rejected by the district fire officer. Accordingly, content is closed.
Kindly post it next week. It has been by Burberry.
So you said you don't count counter. Now second say the content. Now you say no instructions.
Instructions also we need to certain logic. Next week will also
Then you get ready when you do some exercise with prior to otherwise every time you take seek time without.
most of the bundles we have recovered your logic, but still some of the bundles are remaining logic.
When a counter is for everything on record, this we only just have to further that counter. What is then stand is already there on record. What more you can see? Any further develop latest signals only you can say something on this.
But grant language finally logic.
Meeting 11. Step. You have to GP perform. Finally.
Item 20, 21, 22, B. Ramalu, S. Chalapati Rao, GP for editor, B. Timothy.
My lordship, I am representing S. Chalapati Rao. We request for visit time during final counter. We are appearing
After the 6 years.
we are appearing for respondent 9. Respondent one.
By the case, Mr. Ramlu?
Well, counter will renew this hard time for last occasion for final counter Milan. So finally, they have gone 2 weeks time, we used to let them find counter.
1811 finally. No further than that. Also, you are for respondent number 1?
Respondent 9 and
9 is not there. Respondent, there are only 3 responses are there.
They are for third responding. Not responding. University has to file a count.
University is only respondent 1. HIGHCOURT Telangana State.
Agriculture Research Station, University has first respondent in the first place. University has to.
See, your name?
Bharat.
Item 23, A.K. Jayaprakash Rao, GP for Irrigation Services 2.
You have filed a case for a petition with the wife of the ex-employer seeking the regularization service of the husband and further family pension.
What do you say?
They have filed a counter saying that
Counter
services were not converted, it was not regularized also.
Counter. Huh? Counter is not there in the report.
I filed it. I filed another copy of it. There was a copy of with me there.
Counter is there with you.
This one.
But doesn't say what they check again.
This also said, he has also not served the copy. I served the copy.
You prepared counter kept in your bundle or not?
No, but only one copy with me. I will see 3 copies are there, I will have, might have.
No recommendation for the on behalf of Krishna.
Item 25, Kanaka Durga C, GP for Renewable Services.
Yes.
Order given by the dated 27/11, certain secretary.
I finally passed it to Malal Executive Session regarding whether they have been promoted as a superintendent or not. We received also inform.
Item 26, T. Histaya, GP for Corporation, P. Gopal.
Taking up next week, whether it's filing virtual count in this. I've got 2 speakers. First occasion, we will
Counter there and counter 5.
this actual count minutes for the.
I have other development.
So, basing on this cat artist, is a delay of the inquiry, basing on that, is a. Perhaps of the 7 years. The explanation of this delay in the even though it is the inquiry is complete. Now it starts
Inquiry, how many years will take? As per your own rules, is it 3 months or 6 months?
It's a petitioner management and employees also they are not cooperating the court. Inquiry.
Open, then you conclude it. Then there's no.
We can count on national count.
Next week. The request of GP for services 3, no recommendation submission. Request of GP for services 3. Next.
Item 28, Mohammed Osman Shahid, GP for Energy Services के उदय श्री उमा देवी. If the rule of reservation is not already implemented, following the guidelines in the case of Nagaraj, you are considering the earlier entry models, not an entry model was already granted. Following the main relief itself.
Who is it? One. Services 1. Services 3.
State Power Corporation. This is 3 is a formal part.
Minority.
I think on the last occasion, Srimati Umadevi's name was directed to be printed. He is now appearing for the forms number 2, 3, 4, and 5. He is the standing counsel. But all that I am saying is that if the rule of reservation is not already implemented as per Article 16(4), then they have to follow the catch-up rule. And if they are following rule of reservation, then they have to follow the guidelines as laid down in Nagaraj's case by way of collecting information relating to inadequacy of representation and efficiency in services. These are the two exercises that they have to do. Page number 15. There is an order of this court covering the very same issue. Considering the very same entry model method, I was also granted an entry model. And page 17 also another entry model is there.
Please.
Page 15.
Counters. Any counters of fine?
Page 16 is the operating code. In view of the theme following the same, the respondent authorities are directed to verify whether consequential seniority principle is already introduced in the respondent department, granting seniority to employees belonging to SC/ST category promoted in the vacancies reserved for such category. Superseding the general category seniors, and if no such principle is included in the subject regulation and rules, the respondent shall follow the principle laid down in the Supreme Court case of BK Gupta versus Union of India, while effecting the further promotions to various categories of post to which petitioner belong, and such other avoid any such order shall avoid the result of the petition. Another order is on page number 70. There similar order was passed. It is the operating portion.
Who is acting? What about response? We have not filed counter.
No. They have been directed on several occasions to file a counter, they have not. Moreover, on the last occasion, I also passed on an order in WP 47125 where the association filed a similar writ petition for disposal. 47125 2019 for the very same relief, association filed. The relief was granted, considering the very same order, if the lordship can dispose of this petition also, it will be sufficient.
Response or no? Next week, we can dispose of, but we asked to get the respondent also was not there. And there is no counter, no recommendation. Krishna present and we claim that the matter is very short, right? The judgment is possible that this I can we also like running on and
R. Vinod Reddy, K. Amrinder Raju.
I might know. Refer number 5, the card name regarding pension between two wives.
17 minutes.
3 weeks.
3 weeks.
For 7 or 4 weeks.
No definition for the Krishna.
Then 30th.
Standing question for respondent. For respondent 1 to 3. 1 to 3.
1, 2, 3 and 4.
And during the his now my younger brother he appeared and I appeared for this in appeal. So now after review of this 1/4 chair, then this petitioner hearing filed this the final degree petition to partition and giving separate questions. So that final degree petition was meanwhile they have this compromising matter, that's why that has been dismissed. Subsequently, when they have not done now, subsequently another petition is filed for final degree. That has been rejected on the ground that the res judicata. Against that matter, I have filed this CRP number 918 of 19 2019 manner. So when this was pending, so subsequently this in view of this amendment in section 6 of the Hindu Succession Act 2005, this amendment, so where this daughters also they have given an equal share on par with the son. So in view of that matter, that amendment, and as the matter has been not decided finally, final degree proceedings were pending. And I have filed this CRP copy here in this also to show that the final degree petition has been pending and it has not been finalized. So that's why this year this matter came. This previously the Honorable had, and he pleased to order this matter. This to post along with this and that matter. I think was where to the Chief Justice. Now it is coming for your Lordship because that is a connect. That's why it is a connected matter. And your Lordship knows the amended section 6 up to 2005 says when the matter is pending, final decree has been passed. So
there is one Supreme Court judgment. Recent Supreme Court judgment says that there is one thing Justice Nagaratna or Justice.
No, I have filed two judgments. One is Vinita Sharma judgment also.
Sharma says that
yes, they have
well, from the date of from the but they have birthright. They from the
yes, that's
equal right. Now not that the father should survive or
whether he is survive or not survive.
But with regard to pendency final
decree,
there is some one Supreme Court one Supreme Court just verify one Supreme Court judgment says that even a preliminary decree is passed, final decree is pending, and still that is applied.
Yes, correct.
Final decree means only after passing final decree only this is conclusion.
Yes, correct. And your Lordship, there is no the Supreme Court judgments several times given this. There is no limitation of filing. Even so much also they have this courts have to pass this final decree.
Final decree there is no limitation.
But that is also there. In view of this matter,
just check verify the judgment. Supreme Court judgment say that even the cases where preliminary decree is passed, final decree is pending.
Yes.
It's applied.
Yes.
It is not concluded.
Yes. Final decree. That's why I have filed the CRP to show that final degree proceedings were pending.
Only problem that he says he reports no instructions. This because already because still is saying that since long time it is matter is coming back and so this is one of the
also and this actually knows for this matters.
The old matter is always the difficulty.
I know
notice now so.
And that my friend is also senior and
That's
she is
why
also.
problem is these old cases they will not proper representation. They will not respond to any further instruction. They also say helpless. Having engaged the council, they are not.
Yes, they must be also vigilant. The council also says may not get instructed. They must be vigilant.
No, he said that's why I fiscal asked him whether he has informed, spoke to him. He said he has spoke to them. If once they are aware that his matter pending is coming up, they should make alternatives.
Even also please this when it is the problem I have to say, but this I have also been at facing high troubles also in spite of that. I am coming well and doubling the reaction. He is also in the Vajapur. It is a sunset time, and also my client sunset time also. And I have conducted trial, that's why this has a high.
What shall we do in the absence of parties? What shall we do?
Also taken a lot of trouble to serve the notices.
And what shall we do? take out notice, what will you say?
Madam, we have already given madam notices. That is trouble. Again, madam, same trouble which to me, madam. When he has to take this responsibility, he has to address it. Again, madam, it will be very difficult for me, madam. Lot of trouble I have taken, madam. Several times when I noticed it was there. And then this Wakalatama has been filed by this madam. It is their responsibility, madam.
Just,
He has to take the responsibility, sir.
that's why
He has to give.
I told the same thing that he responds. He said also saying helpless, he has informed them, then instruction. At least he has informed them. He said that he already informed them that matter is there, they don't have any instruction.
Yes, madam.
They know.
The same may be regarded as your last proceed, madam. Otherwise, it is very difficult for me, madam. You both have taken a lot of trouble. Even a lot of trouble for issuing these notices. How many that shows, madam, to me.
Appeal filed by you?
It is appeal that they have filed, and this petition I have filed. Let us the appellant here. I was the respondent here. Succeeded half share. Here they have filed this appeal suit. In that 1/4 share is being granted.
What is it?
I have filed this petition.
But what was the rationale in that? What was the rationale while giving that 1/4 only instead of 1/2?
1/4 is because this is ancestral property. At that time it was not there. This is section 6. So his lordship came to the conclusion. This is because she is a daughter. She will get only evidence shows that it is not ancestral property to get the half share. Ancestral property. That's why. Now it is become it is a law. It is a daughter also has that. Same. If they have given my share at the time of only. It is before this, after this passing the judgment and decree, I would have not get this because the final degree proceedings are pending. That's why I didn't get it. This long time they are giving the trouble, even for execution petition, also they have this given trouble. Page number 18, it shows the judgment. It's the his lordship observer. 18.
We'll post on next week. Next week we'll pass out. Let us wait because now today he said that no instruction. Let us post on next week.
Right.
If it doesn't come, we'll post on 18.
5 or what?
To the custom welfare officers here, grade 2, who were initially appointed on consent basis, and it was extended from time to time. Again, in the year 2016, in GOMS has 15 had given your order. Maybe they are issued orders to consider the regularization of the contract employees beneficiary. Petitioner are seeking regularization of their services.
Services 5.
Services 5.
On last step, big statement that she need getting instructions whether these people are continuing with the service or not.
Inform the action plan.
Yeah, password tomorrow, you'll have to start up another matter.
Just a transfer petitioner. Just tomorrow.
Teachers for the for reappointment, and they were continuing in the service unit. And GOS number 16 has been passed, wherein they have clearly stated that regularization of appointment of the contract employees here.
What is GOMS 57? You are relying upon similar pays person for regularized under GOMS 57. Same department or different department?
The GOS was for regularization of services here.
You're seeking same relief because it was extended to other employees under
Yes,
GOMS 57.
Yes, sir.
GOMS 57 is same department or different department?
Different department.
Okay. First one,
Item 33, we mentioned surety MB Ramarao.
Second is likely
17 matter, still you want to. Last time also you have taken time.
Yes, sir. And we have
99 you have taken time. 10 you have taken time. Fourteen 8. 14 8, 29 8, 19 9 and 10. 5 exams you have taken. What's the case? What is the case? What is the case?
That is, petitioner circular, there are declared appointed as series of inspectors. Selected in the year 2007. Now they want to learn. Similar. Those who are working in the battalions, they have to be the finalize of seniority is, this civil size has to be kept in the whole.
Rules are same or different?
Rules are different for these businesses.
Armed reserve and in regular
Similar size are different, and the battalions, those who are recruited in the battalions, that's different.
GP 50. How much time you require? 1811. If you want, then you pay 1 month. 11 penalty with the request of people home. More than 2 weeks. 1811. 2 weeks.
Technician seeking the scale of grade to lab technician. In fact, it was given in 2001 itself, but State Treasury officer took an objection. There is no financial concurrence. In fact, the finance department has to say on that aspect. They are not giving the concurrence on that aspect. We'll file detailed counter. Visit the remarks. And for petition council also.
But finance department will decide your decision.
That's what we'll file 1 week given. And for the petition council also.
Request of TGP plus services to no repetition of people.
Chem 35 Deepak Mishra and Meera Maro.
Appearing for the petition. Question time for the judge.
Counter 5.
Counter is 5.
1. File reply. How much time?
Last week counter was okay. Deserves a reply.
It is 1811. Request of council president for file referring to the counter filed with the respondents.
Item 36 and 37 M. Prabhakar Rao, K. Pawan Kumar, J. Prabhakar, Atul Kumar Agarwal.
In this matter, these two are connected cases. 36 and 37. In 36, the LRs are allowed. 37, the LRs have to be allowed. Preparing for the respondents, madam, we have no objection for the LRs on the system.
In 37, item 37.
Yes.
Then item 15, court of sir. Item 37. This is all. About 36 you are running.
36 they have, which they were allowed last week, last time when they by Honorable Sarath. One is a group for specific performance and other is for partition. It is between the brothers. They both of them are connected. And it seems like we have got some information that respondents also, a few of them have died. So we are yet to take those steps as we get that in the
Delay is no. Delay. What is the delay? Delay is 12 participants.
Yes, Manoj, it is because of
I have to. 3011. Insufficient. There are two only common.
Item 38C, Sai Reddy, GP for services by.
Last occasion. I will complete my.
Yesterday you comment this same thing. Yesterday you made some submissions on this.
Yes. How to continue that?
Watch it so you just not and we accommodate me to do it.
The cooling in fact start for crossover Monday. Monday is already only go to Wednesday. Tuesday working. Tuesday working. Tuesday is it? Tuesday. It's 14. The request of GP for services.
Item 39, Anand.
Lots of out of position.
What about respondents? Response more than no response.
When the chair system is first response manager.
Your name also not there.
Basically, it is the response.
Director of insurance. Who is director of insurance?
Yeah, that is why a lot of them they have to check out what is standing councils are there here for insurance. First, second, and third respondent they have to take out.
So you are applying only for one.
For one. That is common.
Seven. What I'm saying. 7, 20. And 7. Next time. On the ground. Take for person knowledge in 2 and 3.
Item 40 and 41, CH Venkatraman, N. Ram Gopal Rao.
First respondent initiated notification lawsuit for the first aid engineers. By notification 1 of 2015 dated.
Respond is there?
London.
chronological dates I am giving.
That will help.
Better. Submit only 2 lines project.
Two counters have been filed.
2 counters, 1 counter is filed, but it was not in the list. Again, they are filed. You can control on the same line.
Two cases they are filed. Right. 2 cases. Which one you take it? 6.
First one.
610.
610. First one.
6108.
110.
That's not
Cover project.
right.
Nice.
Yes.
The first respondent issued a notification for the assistant engineers. Various notification 1 of dated 29/8 lawsuit for submission of online applications and all the data I have. Once of the issue lawsuit, notification issued, she was selected and she was provisionally selected and given appointment to the post of the assistant engineer in R&B. And after that, the first service commission, first respondent, changed the provisional seniority list, saying that somebody has filed an objection. That is the reason my name was given. That is the reason I approached. Review. Now kindly lawsuit. Page number 28 is the notification lawsuit.
You are 26 or 28?
28.
You are reading fast. Which restriction you are taking?
That's our Roja.
600, sir. 600.
611.
705.
Page number 28.
Okay, problem is that there is some disparity. Page number 28 is struck off and then it is given as 26.
The notification dated is 29/8/2005. 50. In 2 serial number 2 lawsuit. State engineers civil in roads and buildings. 42 posts are there. And page in the next page lawsuit, the required qualifications are mentioned in next page. The assistant engineers must possess diploma in civil engineering awarded by the state lawsuit. And that is second, these qualifications are traditional having. And thereafter lawsuit are certificates were also verified. Result notification is also given lawsuit. That is on 29. Service commission matter, they are filed by. Results are declared in page number, there is no pagination. Result notification is also there lawsuit.
Where? Along with counter or
Lawsuit.
you have filed or they have filed? You have filed or along with counter testing? You are referring some document. What is that?
They are already filed in the
Along with writ petition or page number?
the pagination is not sufficient because counsel is not me, not mine.
But how can I?
Last I have shown the result notification.
After that?
Page number 37 lawsuit. In Zone 6.
Zone 5 and Zone 6.
Zone 6. Fourth one. 9150300484. This is the hall ticket number of the petitioner lawsuit.
Zone 6.
That is called result notification.
Yes.
Page number 45 is the intimation given by the first respondent to the petitioner.
In the reminder.
Yes, sir. And thereafter, next page, 46 I got. Relinquishment letter.
Yes.
She also selected one more post. For that, she relinquished the other lordship, TPPD, and she opted for AE post civil engineer.
Yes. Page 47. What is the last?
Thereafter, lordship, page number 47.
Yes.
After verification of certificates and all those things, and confirmation of our liberty, taking of antecedents and everything. After that, page number 47, para number 2. On the basis of certain representations.
What is the number?
47, lordship, para number 2.
Yes.
Top up.
Yes.
On the basis of certain representation received from the candidates who appeared for verification of certificate and who also possess qualifications equivalent to the higher MET, and commission revises the selection. After completion and after forwarding to the roads and buildings and everything, after that, basing on certain representations, sir, they are revised.
Any proceedings were issued on this, on the recommendation given by other candidates? Any proceedings were issued or no proceedings?
No proceedings, no notice or no nothing. After selection completed everything, they are issued with this revised notification. And I agreed by the same. I appeared before the approached before the tribunal, and the tribunal reserved 2 posts to the petitioners. The interim order. Agreed by the same. Petitions are before law.
Any recommendation given? No. Any recommendation given by
All of a sudden, they declared the result notification by changing the.
So immediately file.
That is the reason only the tribunal indicated lordship.
What is the hard ticket number of the petitioner?
Lordship.
What is the hard ticket number of the petitioner?
Sorry, lordship.
Hard ticket number.
Hall ticket number, lordship. In the 9150, the cost title it was there, lordship. 9150 300 484. Page number 37, lordship, it will clearly mention my name, zone 6. Result declaration notification, assistant in post code. Zone 6. Fourth name selected as. Name or hall ticket number is.
page number 37. Zone 6.
Zone 6.
Selected for 2 posts. After relinquishment of to the post of another department, now they are changing the rules, revised rules. Once the game is started, rules cannot be changed. It is the principle of Washington.
Yes.
Message or countermark.
Yes.
Para 6. So para 6 is commences to with regard to qualification money, candidate should.
Yes. Yes.
And just civil engineering for the diploma in India automatic state board of excellence or equal qualification must possess the Department of Electronic of Computer Courses DOE O level computer qualification administered by the DOE TSHC society under the Minister of Electronics and Diploma of PDF or a diploma or certificate in computer application or equal qualification as required for I submit the commission after conducting the written examination for the post of engineer from 7/11 to conducted for the evaluation of the work of the candidate part of the day. And this declares the results provisionally aligned for to the 10 candidate out of notified quarter to vacancy. Accordingly, the petitioner without ticket number 12 has been provisionally selected for the post of assistant. Yes, it's civil engineering department. But there are several however, I submit that later on the basis of that representation is from the candidate. You appear for verification of certificate in the one of the process qualification dependent to DOE. With higher merit, the commission revised selection for the post of AE in R&D department in excess of hours under 20B of and revised selection in order to protect merit. As a result, in the revised selection, the technician could not get selection due to a low merit. This regard department committee the extract of the 120 of TSHC rules of procedure. Commission shall have the right to correct any clerical, typographical, arithmetical, or other mistake in the merit list, election list, etc. Errors arising therein from any accidental step or omission at any time, either on the own motion or on the application of any of the parties concerned. Further, it's pertinent to focus on the paragraph of the notification number 2 on the reading of commission decision is final. The decision of commission all aspects all the aspects pertaining to application and inspection. Or rejection application any kind of verification but first stages commission the selection for the rest of any candidate and final in all aspects and money in all persons. Under the power vested with it under Article 3 Commission also reserves its right to alter and modify time and condition laid down in the notification for conducting the various stages of the selection will be intermediate different stages to all concerned as warranted by any unforeseen circumstances arising during the course of the process or as deemed necessary by the commission at any stage. In view of the above, the petitioner cannot question the power and jurisdiction of commission on the selection of it and only to protect the merit. I submit that the petitioner was not selected due to a low merit only, but not for any other reason. I submit the commission being the representative agencies to closely follow the GMO rules pertaining to the recruitment in the proper time. Further, in the present recruitment, the qualification step for tomorrow. The report page of statement tomorrow. Only on such representations by other candidates, the thing has to be rated and the person with merit and equal qualification have been selected.
After selection, after she relinquishes her other employment, he won't change it. No notice, no procedure.
That matter, nothing is answered by the commission in this note.
Okay.
Both with regard to low merit only. Nothing for reserving, madam.
Reserve.
42, J. Ravindra, Gadi Praveen Kumar, C. Niranjan Rao.
Find a neat copy in this. During the last agreement, there was an amendment petition which was allowed your lordship under the director to find a neat copy. Your lordship will find it recently and it has not reached your lordship. Your lordship kindly have this matter to one of the.
What was the application filed with me?
The writ of certiorari, your lordship, challenging the termination order passed by the respondent number 4. Respondent number 4 expired, your lordship, so we have filed his death certificate and amendment petition was filed praying to.
Reply file.
Your lordship,
Reply file on
reply was filed, counter was filed.
IA1 amendment of pay
Amendment petition was allowed, your
allowed on
lordship.
30/10/2000. Okay. After that, what is the document you filed before the
Neat copy, your lordship, neat copy was filed, so that it has been made. Then your lordship, we have sought the relief against respondent number 4, your lordship. And respondent number 3 is the official capacity of respondent number 4, in charge and secretary of regional center, your lordship. Now this petition is maintainable against respondent number 3, your lordship. Since respondent number 4 is expired. Which is recently given, that is not reached. That's the reason why I'm asking to have the.
I served copy on the
We have served the copy, your lordship.
council constitution with that concept into emergency meet. Friday.
Item 43, J. Sudhir, GP for services.
Promotion has been granted. We have filed the counter schedule.
Subsequently,
Yes, your lordship, returning
we are
order.
entitled for retrospective. I'm asking for 2011.
But your lordship, there is a order and writ up in your lordship's dated page 52 of my counter affidavit. Wherein I have stated so it's a page 4 of my counter. Order of writ up is page 52, your lordship. And the order has been extracted in counter affidavit in page 4, fourth paragraph.
Yeah. Which page?
Page 4 of my counter affidavit.
No, pair numbers confused.
Page 4.
Virus not counted.
Fourth last paragraph, sir. It is also submitted that during the pendency of the petition, may I read your lordship?
Yes.
during the pendency of the petitioner has been filed WPMP 11086 and 11041 of 17. Orders were issued dated 13/6/2017 directing the respondent. If the respondents are taking steps to fill up the existing vacancies in the category of Assistant Commissioner of Labour, the claim of the petitioner shall be considered as per her eligibility and suitability on par with others. It is admitted that petitioner again filed a writ in 430 of 17 against interlocked orders passed by the Honorable Landed Single Judge in WPMP 11086 and 11041 of 17 in the petition number 8909 of 17. And the Honorable Court orders dated 6/4/2017 are issued direction to the respondent to consider the petitioner claim for promotion on ad hoc basis, along with the other eligible candidates. In compliance with the order, the Honorable Court mentioned the petitioner to consider promotion the post of Assistant Labour Labour Officer to Assistant Labour Commissioner in 2018. Orders were issued proceedings dated 12/9/2018. We have issued proceedings here, Lordship. And she was posted as Assistant Commissioner Labour at Rangareddy District. Copy of the proceedings also we have enclosed away. And also submitted petitioner subsequently promoted from category Assistant Commissioner Labour to the post of Deputy Commissioner Labour by dated GOMS number 7 dated 31/7/2021. And also she was posted as Deputy Chief Executive Officer, Telangana Building and other construction of Welfare Board, Hyderabad by GORT number 50. That is enclosed at
Yes.
Page 57 we have enclosed here. And also GORT number 50 consisting of pages have been marked out. Submitted during the pendency of the petition, she was promoted from category Assistant Labour Officer to Assistant Commissioner of Labour in the year 2018, and also subsequently got promotion from category Assistant Commissioner Labour to the post of Deputy Commissioner of Labour in the year 2021.
Yes.
In view of this, the promotions, the government of Andhra Pradesh Labour Department ought to have provided the seniority as on 1/6/2014 in terms of even reorganization act for allocation of employees. But so far as seniority list in category of Assistant Commissioner Labour was not furnished, it is not out of place to submit the Honorable Court to another petition 26765 and filed by previous Supreme DCL retired another passed direction on 29/8 to the official respondent number 3 Commissioner Labour to pick seniority of the candidates as per in terms of AP Reorganization Act consisting and it is submitted that as regards to the seniority list and review of seniority list in category of Assistant Commissioner Labour, the first respondent herein requested the Special Officer Secretary Government LET and F Department, Government of Andhra Pradesh, Vijayawada by letter 7/2022. 22, and the same has been published by the Andhra Pradesh consisting of clear expectation.
Yes.
Can you see the prayer or what is it? Prayer. Direct the respondents to promote the petition as Assistant Commissioner of Labour with effect on the date on which her immediate leader was promoted, that is with effect on 30th May 2011, by conducting review DPC in the teeth of completion of penalty period by October 2011, or in alternate, direct the respondents to promote the petition as Assistant Commissioner of Labour in the subsequent panel year, that is 2012, for which she is otherwise eligible in law, keeping in view the vacancies with all consequential benefit and further promotion and fixation of pay, etc., by holding the acts of the response. In not doing so, despite several representations by setting aside impugn proceedings related also, through which her claim was rejected by the also as bad by issuance of interment. So, by claim relates back to 2011. They promoted, they are under the impression that I am promoted, but I am promoted in 2018.
After 7 years.
After 7 years. and subsequently, otherwise, my lord, I would have been promoted in 2018. I would have been deputy commissioner and more. If you lordships have a look at, my lord, page 13. Page 13 is the seniority list. My lord, this is a promotion from assistant labor officer to assistant commissioner of labor.
Yes.
If your lordship sees the page 13, that's the seniority list. And of assistant labor officer, she was appointed as assistant labor officer. Then, my lord, at page 16, my lord, item number 68 is the position of the petitioner. Sridevi, joined on 30th May 1995. Then, my lord, lordship can return to a penalty was issued, my lord, at page 17. Stoppage of one increment at page 18, lordship. Penalty was issued on 18/10/2010. Just before about to be, I was promoted. Per 8, accordingly, punishment of stoppage of one annual grade increment without cumulative effect is imposed. But the effect of this, but it was issued in October 2010. But what will be the effect of the punishments on the promotion is at page 50. There is a GO specifically given by the government as a policy. At page 50, that is GOM Mr. 342.
Yes.
That is the effect of that penalty. What will be the effect on the future that incumbent? That is what kindly see page 50. The heading itself speaks. AP so on so minor penalties, effect of penalty. That's the heading. And not speaking last para, the need for issue para 3. Comprehensive instructions on the currency and effect of minor penalties on government employees who are involved in disciplinary cases and who come up for consideration for promotion to higher categories has been examined and further instructions are issued as follows. So if a punishment is issued sanction, what will be the effect? Like that, we are concerned with withholding of increments of pay without, because the punishment was without, which will come at page 52. Stoppage of increments without cumulative effect. B. A monod is with cumulative effect, lordship in the earlier page. The penalty awarded to governments, this on the right hand column, shall debar him, her, for promotion appointment by transfer to a higher post during the period of subsistence of penalty, which shall be indicated in the order subject to a minimum period of 1 year, both for selection and non-selection. First of all, minimum of 1 year.
Yes.
And the penalty order should actually say that I am not entitled for how long. They did not say so.
If you are taking 1 year.
1 year. That means if you take 51, minimum is 1 year. So by October 2011, I am eligible.
But you are in the prayer you have taken the 30th May 2011.
Because my prayer, if your lordship sees, that's why October 2011, 1 year period will be over because October 2010 was the punishment. So therefore, 1 year if it is taken, though they have not mentioned. But either that is why, even assuming that even by 2011 I am not eligible, I am entitled for 12. Because all this is not mentioned by them also. October 2011, but actually, when you are promoting, they will take 1st September. Lots of observed. 1st September, 1/9 is taken. So by 1/9 punishment is there. Therefore, I may not be entitled for 2011. That's why I said, alternately in the next, that is in 2012. Now, what is given from the counter is that I was promoted.
18.
In a normal recourse, whatever happened. The retrospect, there is no mention about my contention. Kindly see my contention. Page 8, para 8, page 7. Sorry, I failed to bring it lots of kind notice. Juniors promoted on 30th March 2011. Sorry, May 2011. That is, your lordships will see mirrored at page 422. 7 of them. I was denied obviously because I was under punishment.
But after this 1 year period, suppose say
1 year period, Lord, they will be promotions. There were several. I am entitled after 1 year.
Rated, but subject to their vacancies.
Vacancies were there
2012.
from 2011, 2018, Lord, they gave me promotions. Is it their case that in between there was no vacancy? That's the issue.
We have stated in our counter affidavit,
Hey.
para 3 and 4 here.
What did you say?
Para page 3, your lordship. Petitioner was trapped in ACB case, your lordship. She was awarded punishment for stoppage of annual grade increment without cumulative effect. That is dated 18/10/2010, your lordship. Wherein it is submitted recruitment and promotion. Para 7, your lordships are gone. It submitted that Departmental Promotion Committee for the year 2010-11 post of Commissioner Labor met during the month of May 2018, composite of AP, and the committee taking into account the punishment of period 1 year, that is till 17/10/2011. As per rule, the rule para 3
3-4B.
GMS number
342.
dated 4/8/1997. Department has not considered her candidature for promotion to the post of president. In this para 8, it is submitted that rule position under para 3 of GMS number 2087 is as follows. A is purpose to review departmental promotion. It has been decided that in respect of following cases, matter should be placed before Department Promotion Committee for review. In addition to the circumstances mentioned in GMS number 32, we have given here 32 dated 22/1/1981. When eligible persons were omitted to be considered or ineligible persons were considered by mistake, the seniority of a person is revised with retrospective effect. To differ with seniority list placed before the earlier Department Promotion Committee, where some procedural irregularities were committed by the Department Promotion Committee. When adverse remarks of confidential reports were toned down and expunged after departmental promotion had decided the case of the officer. Cases of the persons considered and included in the panel here in terms of GMS number 424 dated 25/1, but who were subsequently awarded minor punishment. Further, when the review departmental promotion committee meets, it should be considered only persons who are eligible as on date of original Department Promotion Committee meeting, except in cases of covered by GOMS number 32. In view of the rule position, in view of petitioner's ineligibility, her name was not proposed for review. Accordingly, her representation were rejected. It is respected as the government of AP level not give any final seniority list in cadre of junior assistant and labor assistant before the appointing day 1/6/2014. It is submitted due to administrative exigency. Department Promotions Committee for category of assistant commissioner labor from 2011 to 17 were not held. As per Government of AP, Labor Department is doing an exercise on seniority in category of assistant labor officer, and this office has taken up ad hoc promotion in category of assistant labor and assistant commissioner of labor.
As you lots of just have heard, there may not be a possibility of review under 187. Under 187. That's why it is rejected. Actually, rejection order lordships can see at page 49, that is reviewed in the late petition, page 49. is the rejection order. Because of 187. They refer to 187 GO, talking about fraud review DPC. 187 postulates fraud or prescribes the procedure for review DPC, which is, Lordships will see the rejection order at page 49.
Yes.
But GMS number 182 is at 43. 43 below para 13, that is what is extracted in the counter.
Page part 3.
Sorry, below 186 7 GO talks about, it starts at page 43, that the heading is Department Promotion Committee, the reconstitution and guidelines.
Yes.
So how to conduct DPCs, upon which 13 para 13 is relevant, which talks about review DPC.
Page.
What they say is, I do not fall. Review DPC can be conducted within these parameters only. That is, when the eligible persons were omitted to be considered. Ineligible persons who were considered by mistake. When the seniority of a person is revised. When some procedural irregularity happened. When adverse remarks of the so-and-so were thrown down or expunged after the APC. So such of the only will be considered. So therefore, there is no question of DPC. That's why first para may not be considered. First portion of the prayer. But then I mentioned for 2012, for review DPC of 2010, for which they are conducted, where 7 people were considered. I was asking for review DPC. Review DPC cannot be given. But that's why, you will also clearly see the prayer. If I am not entitled, alternatively ask for the next panel here. See the second prayer, Lord.
Promotions have stated in paragraph page 5 of my counters. APA government is pending because AP government has to be new parties. Promotion.
After bifurcation reorganization, what?
Sorry.
No, they want the AP government to be made party.
I have stated in counter with page 5, as per review of promotions, the government of AP Labour Department ought to have provided the seniority list. Seniority as on 1/6/2014. I have read just now. I have read.
Yes. Page.
Page 5 of my counter with last paragraph.
Last paragraph, yes. As regards review of promotion.
Review promotions of the government of Andhra Pradesh Labour Department ought to provide the seniorities as on 1/6/2000 in terms of AP Reorganization Act for allocation of employees. But so far as seniority list is list in category of Assistant Commissioner level was not furnished, it is not out of place to admit that Honorable Court in another petition number 26765 of 21 is filed and previous Subramaniam, DCL letter and others has passed the direction on 29/8/22 to the official respondent Commissioner AP Vijayawada to fix seniority candidates in terms of AP Reorganization Act 2014, consisting of 4 pages and margin exclusive. This advertisement in regard to seniority and review of seniority in category of Assistant Commissioner, the first respondent herein requested the Special Chief Secretary, Government, Labour Department, AP Vijayawada, while letter 67 and same to be furnished by AP.
What they are saying, what telling is the counter. At page 4.
Yes.
They are not saying that there are no vacancies. I suffered a penalty and therefore I am not entitled for 1 year.
1 year.
That is clear. I may not be entitled for the promotion under review DPC because 187 para 13 says it is not possible. Say therefore, I may not be right in asking for review DPC because review DPC, actual DPC conducted in May 2010, 2011 during the penalty period. Therefore, though the possibility is there, I am entitled for at least next year because 1 year is over. What they say is we have not conducted DPC. There is a vacancy, I am entitled for consideration. You cannot keep it for 1 year. They said you are not eligible because of this penalty. But when I become clean, or the problem cloud I had was taken away. But subsequently, I am supposed to get promotion because every year they have to do parallel. Every year they have to make promotions. From 2011 to 17, kindly see page 4. Page 4. For 6 years, for 7 years, for 6 years, they have got page 4 of the counter.
Yes.
Third para, it is submitted that due to administrative exigencies, this is a very convenient way of using the expression. The departmental promotion committee so also of the category of Assistant Commissioner of Labour from 2011 to 17 were not held.
Any vacancies are available here, Lordship?
Let them say there is no vacancy, I will go out of the court.
As per
They don't. 1 second, madam. 1 second. If there is no vacancy, I am out of the court. Because I can only ask for the if there is a vacancy only, I can claim. They did not say there are no vacancies. But due to administrative, the very language itself says that there are vacancies but still could not be. Due to administrative exigencies, DPC for so and so were not held. Not that there are no vacancies. And they are supposed to draw the panels every year. As on 1/9/2000 every year. So as on 1/9/2012, I am eligible. My juniors are already working in the higher post. You cannot keep the vacancies pending for the administrative exigency and then say that you were promoted in 2017, you be happy with it. It's illegal because by prayer B, direct the response to promote the petitioner as Assistant Commissioner of Labour in the subsequent year. Earlier for A road, I asked for 2011. Subsequent year, parallel year, for which she is otherwise entitled in law, keeping in view the vacancies with all consequential benefit and further promotions and fixation of pay, etc. by setting aside the implement proceedings. That's why Lordship sees
They also make another point saying that the state of AP
first of all, let them find out whether there are vacancies or not. They have not denied that there are no vacancies. Paragraph 13 of my petition.
Yes.
That there are several vacancies of Assistant Commissioner of Labour, but no steps have been taken to fill up the said vacancies on regular basis. Petitioner is entitled as stated above from the date on which her juniors were promoted, or at least in the next panel year, and not doing so is leading to miscarriage of justice. So there are specifically avoided that there are vacancies and there is no denial in the counter, subject to correction. In para 12, I stated, secondly, the petition is also claiming for promotion to the post of so at least in a subsequent panel year. The petitioner became eligible after suffering 1 year punishment in October 2011, and therefore the claim of the petitioner should have been considered for 2011-12 panel or at least 12-13 panel. However, unfortunately, no panels have been drawn, and that is admitted. Since then, and no promotions have been given. Though there is a requirement that year-wise panels to be drawn, depending upon the vacancies, the response failed in their duty to do so. And by virtue of not filling up the available vacancies, public existing vacancies, of sorts, a situation has arisen where the petitioner is continuing as assistant labor officer while her juniors are functioning as assistant commissioner of labor, and some of them as deputy. It's a clear case, Lord, where I do understand that I suffered. But when the vacancies are there, you cannot keep them in cold storage and then say that we don't hold it, and then held it only in 2017.
Yes.
There is no answer to this Lord in the counter affidavit saying that there are no vacancies. That's why we did not hold.
What is
If the vacancies are there, Lord, then I'm entitled.
With regard to this issue, Lordship, petitioner preferred, your Lordship have preferred an appeal. When in appeal, there was a direction that page 52 of my counter affidavit.
yes.
Let me clarify that, Lord. There is an interim direction by this Honorable Court, Justice Naveen Rao, saying that if you are eligible, only you can be considered. I find that no, that is there. And then, Lord, against which I prefer writ appeal. Writ appeal was disposed of by Justice Ramesh Ranganathan as the Chief Justice, as he then was, by stating that is at page, Lord, Lordships can see. That's filed by them, I think.
52
Yes,
and
52, 52, Lordship can see.
Yes.
It's there.
One second. 52.
Yes. It appeal was 430.
Writ appeal is interim, when the interim directions are. So all the observations, what all they did was kindly see, Lord, 52. It's an against interim direction.
Yes.
It is not that Lordships are supposed to be bound by this, because it's only an interlocutory thing. All these things will merge with your Lordship's final order. As an interim 52 at page 52, kindly go to page 53. Page 53, second paragraph, so and so learned counsel would request this court to at least direct the respondents to consult the this case for promotion as an assistant commissioner of labor on ad hoc basis. While no mandamus can be issued to the government to promote a particular officer, be it on regular basis or ad hoc basis, the respondents can always be directed to consider the request of the petitioner to be promoted on ad hoc basis in accordance with law, along with the other eligible candidates. We consider it appropriate, therefore, to direct the respondents herein to consider the petitioner's claim for promotion on ad hoc basis, along with other eligible candidates at the earliest within 2 months. But because promotions are not being given, as an interpretation I sought to at least promote me on ad hoc basis by juniors are continuing.
Yes.
Therefore, our division bench also said ad hoc you can give. That doesn't mean if I get an ad hoc in 2017, I am not entitled to seek your Lordship's indulgence for it insofar as main prayer is concerned. So this writ appeal has its death, it is over. And we file a contempt, and contempt is also closed. Because she is promoted in 2017 subsequently. Page 54 of the counter is subsequent promotion.
2018.
From 2018. For 18-19 panel. Kindly see page 54, last but one para.
Which one?
Page 54 by promotion as assistant commissioner of labor.
Yes.
On 12/9/2018, order was passed by the division bench on 6th April 2017. They have not given ad hoc, but meanwhile, promotions are given on it regular basis.
Page 55, Lordships may only see.
One second, in pursuance of last part one, in pursuance of the orders the government mentioned above, the DPC for the second level gazetted post met on so and so for considering the individuals in the cadre of assistant labor officers and superintendents, which are feeder cadets for the panel year 2018-19 as per the special rules. Therefore, these are the persons promoted because I am the senior most. She is shown at serial number 1. And this writ petition is also subject to the cases pending and all.
Page 55, para 5. 4 and 5.
Yes.
Subject to these conditions only, we have issued some financial guarantee.
Still remain, my lord, I am treated as a person who was promoted in panel year 2018-19. Based on which I got promotion as deputy commissioner also.
Only 2 points. Say that whether there were any vacancies after 2012.
Order your lordships may 52 wherein
Yeah,
existing
zero.
vacancies. When writ appeal they have stated that existing vacancies. Prior to your lordship, in order to under appeal, then single stage observed that there is no positive direction as sought in 2 miscellaneous petitions could be granted at this stage.
All right, I have
Such a claim
1
could
second.
not be considered.
All right, I'm
And at the time of consideration, the petition, if the petitioner is otherwise eligible, there are vacancies, and if the respondents are taking steps to fill up the existing vacancies, the claim of the petitioner shall be considered. After writ appeal, your lordship, they have considered promotion, and promotion has been granted now in 2018.
Lord, I'm sorry, my lord. I think fundamental and rudimentary principle is the interim directions passed during the pendency of that will not come in the way of the writ petition. We have to go to the basics.
But
Can this writ appeal, 1 second, madam? Can this writ appeal order restrict my claim in the writ petition? Writ appeal order is the interregnum period.
No, what in fact what they say is promotion was given only considering this interim order.
No, they did not say so. Kindly see the promotion order, my lord. Kindly see the promotion order, page 54. They are violated because the direction is to give ad hoc, not regular. The direction by the division bench is to give ad hoc. That does not take away my right. By passing an order in writ appeal, my writ petition doesn't become infructuous. My brain is with effect from lordship's laws. Every interim direction passed is in the aid of or within the parameters. But that interim direction cannot eat away my writ petition prayer.
That is fine, but the only thing what now they say that
Not only that, promotion order doesn't talk about the writ promotion I got as a normal course because they have conducted in 2018 or so. There I got it because I am the senior most, by which time the cloud was over and there was a gap of about 7 years. Promoted on regular basis. This is not ad hoc basis. After DPC.
any promotions were effected in 2012, 13, after 12 to 17.
As per my count, or I have no instructions with regard to level to what.
No, 11 is not eligible. Only after 12 she is entitled.
They have stated in counter affidavit, they are stating that from 11 to 17 there were no promotion vacancies.
No.
No, wait, not with regard to not vacancies. There were no promotion.
Page 4, they said there are. We have not conducted due to administrative exigencies. Not that there are no vacancies. It is impossible not to have vacancies for 4 years. Nobody has retired in those 4 years. Let them say so, but there is no. 1 second. Let them say that no vacancy arose in the cadre of Assistant Commissioner of Labour between 2011 to 2017. Therefore, we have not conducted. Therefore, you got promoted in 2018. Be happy with that. If that be the case, I will be out to the court. They have an obligation under the state and subordinate service rules to conduct panel. They cannot simply say, panel, I did not prepare administrative exigencies. I can understand 1 year. What is the administrative exigency? How can you? All of them were going on ad hoc. That's what I've said in the affidavit. You are continuing on ad hoc. Even ad hoc is not being given. That's why the division bench said, okay, at least you give on ad hoc. That was not given. Even ad hoc was not given. Directly I got promotion as a regular
promotion.
In 54. That too, kindly see the order of the division bench brought is at 52. It was passed on 6th April 2017 to give me ad hoc. At least ad hoc considered along with others. In April, and I get promotion only in 18 of September.
In fact, in the 12/9/2018 promotion, the proceedings, the writ appeal date
No,
is not mentioned.
It is not, this has not been complied with, but subsequently, because I got contempt is subsequently closed. They have to pass orders within 2 months.
What about this page 5, the last para? They want, in fact,
Which page?
Counter page 5, last para.
Yes.
So there, in fact, they are in fact, they are having they are taking 2 grounds. One is that 11 to 17, in fact, no promotions were affected due to administrative exigencies. One. Secondly, they said CNET was not, in fact, finalized. And the state of AP not furnished the list.
They have not furnished. What are the efforts on your side? What are the efforts on this time? And there is already a seniority list. They want a seniority list up to 2014.
Yes.
As on 1/6 bifurcation. But even before, I am entitled in 2012, where there is already a seniority list which you not have seen. I am at 68. So, can you also appreciate if there is no list up to 1/6/2014, as per the para of last para, how did you give promotions in 2018? You have followed some seniority list.
Subsequently, that's part.
No,
Subsequently, they prepared this.
Correct. No, this is filed in August. This counter is filed in August 2023, saying that we have, saying that we don't have anything to take up steps. If that be so, from 2014 to 2023, you say there is no seniority list, valid seniority list up to 1/6/2014. If that be so, how did you make promotions in 2018? On what basis? It is based upon the seniority list which is already existing.
Where is that list? We are saying 16.
Seniority list, your lordships will get it.
Page 15, it is there.
Your lordships may kindly see the seniority list at page 13 of the report issue.
2008.
It's a final seniority list.
Your question starts at 68.
68. All the persons, in May, the promotions are given. 7 persons were kindly go to page 22, where I was denied because of the penalties at page 22. These persons,
the 32.
These persons, I am at 68. Sham Sundar is at 71. 10th item is Ram Gopal is 77, 78.
So they are all
juniors to me. They were all juniors to me and rightly promoted because I was suffering the penalty. But now, when 2018 promotions are given, subsequently other persons are also
2012
because I was the senior most, I was treated as number 1 in the 2018 promotions. Now, conveniently saying that we don't have a senior list. There are 2 things. If there is no senior list, how did you make promotions in 2018? On what basis? Secondly, what are the efforts on you to get a senior list? You cannot simply throw the blame on the neighboring state saying that they did not send.
Even in combined list, you start.
Yes, it will be there. Combined list, my seniority will not change.
You are on higher court.
Yes.
Then the 32 members, the 32 officers who have been promoted in 2011, in fact, they are junior to section.
If you lordship sees page 55 in juxtaposition with the seniorities, Sridevi is at 68.
Yes.
And Kantamma, next other people, they are all there. They are all promoted along with me.
No, only point now is that
I am entitled for. You cannot take away my right to be considered for 2012, 13, 14.
2012 to, that's why now 2012 to.
It's a promotion list.
Which one?
Page 22.
No, promotion list, promotion. What is the basis?
What
is the basis for promotion?
You
have promoted some officers who are in fact junior to the petitioners.
My friend is thinking that I am showing the junior promotion list as a senior list. Senior list is at page 13. Promotion list is at page 20.
Come back to page 16, page 15, 16. Page 15, in fact, the list starts with page 15, the seniority list. At 16, serial number 68, the Christian name is there. Serial number 68, KC Devi. And come back to page 23, who have been promoted. Shanti Bai, Shamsundar Reddy, in fact, they are at 71. Serial number 71 is Shamsundar. No, Shamsundar Reddy, Shamsundar George. There is some difference is there. My 71, Shamsundar 71.
62. He stands already with 62.
No, Shamsundar Reddy is there. 62.
62.
Above her. What about the Rajendra Prasad, Krishnamurthy?
About 4 or 5 people are above me. Promotion. Serial number 1 to 7 are by CS.
1 to 7. Then 8. A number.
8 I have to check. 9 is 71.
Shamsundar George 71.
And kindly go to 25 Road. Kaisar Sajid. He is at 106.
Yes. So even take this, these are all, in fact, from serial number 9 to 32, there appears to be junior. So if you take up, if had you taken up the promotion the next year, 2012, 13, whatever.
Yes.
The Krishna will have been considered after lapse of 1 year mandatory period.
Not takes page 55, where fresh promotions are given in 2018. I was shown as number 1, and the other person were not. Srinivas Gaud, item number 4 is below in that text position. If you not 6, Srinivas Gaud is 82. Some people must have retired or whatever. Then you wrote Bharati. They are all below. This is followed.
Yes.
Vacancy position, they are there. But under Rule 6 of the State Somewhat Service Rules, Parallel has to be prepared. Retrospectively, I am entitled. I cannot be promoted with much juniors to me and then be happy about it. When I am entitled from 2012. That's why simple.
At least you have promoted 2018.
18, I got it. Something is better than nothing. But there is also a saying word, nothing is better than nonsense.
Just only clarify on this point.
Yes.
And
find out the vacancy.
Council.
GP1 clarifying on the aspect.
Whether there is any vacancies. Promotions on SCL 2.4. Yes.
Item 44, D. Lingarao, GP for Revenue Services. Item 44. D. Lingarao, GP for Revenue Services.
Fine. Right, counter.
But I am ready. The Quadris files a matter of dismissal of service ballot, where the petitioner challenged that Rule 20 has not met.
CCA rules. Fully prepared.
Yeah, prepared ballot.
Tomorrow. Oh, the request of council. Krishna. Oh, no.
Item 45, K. Ajay Kumar, J. Srinivas Reddy.
The pay. RTC, who is there? Previously was there, he was sitting here. To ensure the presence, you need to cut off. You need to catch hold of him, then sit.
He said he will come back. Can you pause on
I'm not RTC council. Pause. Attention.
Item 46, J. R. Manohar Rao, GP for Service 3.
Your Lordship, in this matter, counter not filed in Lordship. 10 days में देख रहा है.
और condition कर रहा है. अनुज आगे का पिछले. $18.11. No further time.
Item 48, G. Ravi Mohan, GP for Labor, N. Bhupal Reddy, Jatam Srinivas.
Ravi Mohan. Notification from Assembly of Questions from Standing Council.
This is I beg to represent Srinivas Rao Millard. This is coming up for instructions Millard. When it came up before the other learned judge Millard, the other side has taken a time that they would be filing a counter Millard. This repetition is covered by two orders of this honorable court Millard. Millard, writ petitioners Millard are seeking pursuant to their representation dated 18/11/2010 Millard, they are seeking consideration Millard, if they are eligible Millard. Your lordship may kindly come to page 22 of my representation.
Is a free call.
remarks, file a counter.
When
May I just make one request, Millard? Your lordship may, with great respect, your lordship may kindly see the docket, Millard, when it came up before the other learned judge. Millard, other side has taken about half a dozen adjournments on the pretext of filing counter. Millard, my case is clearly covered by two two judgments of this court. Millard, your lordship may kindly see the docket for a minute, Millard. Millard, I am the last person to oppose, Millard. Your lordship may kindly see the docket.
Yes.
For some reason or the other, Millard, I supplied the covered order copies. My friend said he pointed out, Millard, he took an objection on Millard, on a maintainability. That also, Millard, I answered. Cutoff date, Millard, regarding that he raised an objection. That also I answered. Millard, on previous occasion he said parawise remarks are ready, counter is ready. Now again, Millard, my friend is asking adjournment, Millard.
A counter is ready, my lord. We received para-wise remarks.
Milord, the same representation was made before the other learned judge. Milord, your lordship may kindly appreciate. Milord.
This you want. 12-9 you have taken time. 27-9
Yes,
you have taken time.
Yes.
13-9 you have taken time.
They are based on representation.
4-9, 6-9.
Long before bifurcation of the respondent.
Correct.
Finally, 2 weeks may be granted.
No, Milord, this is going on. Milord, they cannot, Milord, for every time, Milord, they are asking Milord to, Milord, let them at least undertake, because in the last occasion, Milord, I have made a representation. They have not considered. Milord, my friend made a statement in the open court saying that writ petitioner was communicated by a notice. Then, Milord, I requested my friend to furnish a copy. Milord, let him furnish a copy to the satisfaction of the court. Milord, if at all he has addressed any letter. Milord, 811. Thereafter also I have made a representation. Milord, without Milord there being any marking a copy to the petitioner, Milord, my friend is not. It's not proper on my friend to make a representation saying that a letter has been addressed. Milord, with great.
What letter? What is the letter address?
Milord, they have Milord, my friend stated that a writ petitioner has been communicated through a representation saying that his case has been considered. Milord, we have not received any. Milord, on instructions from my client, Milord, I am making a submission before the court. We have not received any communication. Milord, though it is not recorded, if your lordship sees, my friend made a statement in the court saying that writ petitioner has been communicated pursuant to the representation I made on 811. Milord, that your lordship will find at page 20 and 22. Thereafter also I made another representation. My friend says that a writ petitioner is communicated pursuant to this representation. Let him show one piece of paper to the satisfaction of the court, say that.
Once again, 1310, in fact, has undertaken that he will argue the matter if the count is not filed.
Yes.
The recording, in fact, is 1310.
Yes.
Those representations, my learned friend is referring to is of 2010. The cutoff date was fixed on 4th December 2016 after thorough discussions with the trade unions mediated by the Joint Commissioner of Labour. I was questioning because trade unions and the Joint Commissioner of Labour are not parties to the petition. I only questioned that one. This calls for a detailed counter affidavit. But finally,
How many dates will take?
no, they are taking.
See, you are only undertaking 1310, that you will argue the matter based on the pleadings.
Yes, my lord. The respondent corporation, because the events took place before bifurcation of the respondent corporation. They are taking some more time. That's all. Now, henceforth,
I take in 2014, now we are 23.
I won't take adjournments. My lord. Finally, 2 weeks may be granted.
Milord, your lordship may say no further adjournment, Milord.
$1811.
1811. Finally, your lordship may say with great respect.
2511, because it is taking.
2511 Saturday, 1811 working Saturday, the exposure game. 2511 is no argument.
1811, your lordship may say.
No, I'm seeking further time.
No, Milord, Milord, I am the last person to oppose, Milord, but for their Milord, repeated adjournments, Milord, I am opposing. Otherwise, I am the last person to oppose like this, Milord. Milord, it's all covered by 2 orders of this court, Milord. They have not chosen to file any appeal. Milord, the 2 orders are staring at them.
And then at the request of counsel for
I am grateful, Milord.
Item 50, Gopal Krishna Kalanidhi, GP for Finance and Planning. Services one.
And today we start time for finally taking the comparison service and even take to find and to as a large chance no problem.
Presenting on paper presentation of the workshop. And post on Monday, so you will comment after the matter.
Our counter who is applying for respondent.
Has read from service ownership, it is basically means.
59 years, 2017.
17 years. Now to
What remains is the age 65 years.
Yes,
Even according to the age which is given in the restriction. In 2017, patient is filed. At the time, age 59 years.
His statement has been rejected your worship from 15 to 2016.
What remains?
Any benefits, pension benefits.
There is that any? Have you sought anything?
Report from Monday. Instructions.
Your query is only with regard to the challenge rejection of election order. There is no further release for you. Take in section. Please find out the spontaneous. What is better? You have got the copy of better update 2021 when better update has been filed. What purpose? Yes, the request of consultation.
After 51 years.
Yes.
The virtual university has filed a detailed counter. Matter parties to the limit of details of Sadia of this.
You are applying for
Petitioner petition.
For the petition.
counter is filed.
Counter is filed. My learned friend want to file reply to this.
And when the counter was when the
It's
counter
already filed.
when
1 week at 25.
the request of council of Krishna filing reply 1811.
I have 56 years.
Yes. Also for your
That's my item number 59 lots. Why not? If the kind is 59.
Yes.
Why not redo lots? The problem.
Here only first person to say other in fact the GP they were saying about file is not being this
Problem. Thank you for the next week lots. Ready for the
should not take time. You are saying very.
The respondent is saying, last two occasions, they were sitting the argument, and now they're telling file is not.
1711 or 1811. Come on, Saturday. Question 1811. 17. Yes.
Item number 52. Vera.
50?
52. Yeah.
Yes.
GP.
Ramu
To change
Nagapur
Wakana
became
TSHC
a
as GP.
Please then.
And Wakalat they are filed as HIGHCOURT. And
52.
inform me. And inform.
In constitutional depend that constitution appoint
52 connected.
53 also same. 53 connected.
53 is connected.
Then you see after lunch then since it's all
Yes.
going to be both easy. Yes.
Excuse me, is Madam or Sir Court Master available? Good afternoon. Is the court master available?
AB posting. Password matters. Item 4B, Subhash GP for whom? M.E. Ramarao.
Yes.
Left the code because he is not well.
Yes.
This case.
Only just recollect this.
In the judgment of Honorable Supreme Court of India in case of Maharika Infrastructure versus State of Maharashtra.
Only
Court of India, how I recognize the scope of 482 CRPC in this.
No, one second. Only point is, in fact, the other employees, they consider the suspension period as continuity in service.
Yes, yes.
Only for the prisoner, in fact, there is a discrimination, in fact, treated differently. And he also filed, like, you see the document, 50, annexure 11 to 14, I think. Why he was singled out? Because exonerated from all the whatever charges in fact framed against him.
Here, Millard, the issue is how to treat the suspension period.
Yes.
The principle, Millard, is that he was placed under suspension because he was a criminal case is registered against him. Honorable Supreme Court, Millard, a similar plea was raised that since he is exonerated in the criminal case, acquitted in the criminal case, it should be treated as on duty. In the judgment, my colleague passed on TSHC was a provocateur.
Yes.
Consider the scope of FR 54B. That it's not automatic. You have to see in what circumstance the case, criminal case was acquitted. If not that fault of department that he was placed on suspension, was involved in a criminal case. Yes, the observation of Supreme Court that he was, because he was involved in a criminal case, he was suspended. What the department has to see, authority has to see, when there is a suspension period, if the suspension was justified as on the date of placing him on a suspension, not based on subsequent events.
Oh,
so, in other cases, I don't know the circumstance under which.
You go through all the documents. In fact, they have in fact grave offences than this prisoner. In fact, the offence, in fact, allegations made against them, in fact, grave more than grave from, in fact,
What is this?
than the petitioner. When you have extended the benefit to others similarly placed, why can't?
So far as this page 55 minutes, here also case of corruption, my lord.
Yes.
Page 55 watching mechanism.
Yes.
There are 4 onwards.
Yes.
In the GO third report, orders were issued prosecuting the accused officer, so and so, so and so. Court of law for the offence of punishment section 713, 2 Red Bit 13 Monday of the Prevention of Corruption Act. In the judgment pronounced on 7/9/2010 by the First Division Special Judge, the court has found the accused officers, Constable Homeguard, not guilty of the charges framed against them on the second count. The reference court cited investigating agency while furnishing a copy of judgment has informed the First Division Special Judge about one judgment on 27/9/2010, finding the accused officers so and so not found guilty of the charges framed against them. As further informed that Bureau is of the opinion that it is not a fit case for different appeal. The reference 6 above orders were issued dropping further action against so and so employees as they were acquitted. And acquitted on section 12. Here I your watch. The reference 7th above Director General of Police Andhra Pradesh Hyderabad has requested the government to issue order.
Yes.
This order, my lord, it is not clear what was the case against, what were the facts of the case against them. Except case registered in corruption, merely because sections are same in this case and that case. Cannot be said. The principle is that, my lord, it is not treating suspension period as on duty, even after acquittal, is not automatic.
No, all the cases you have not preferred appeal. He said that is not a fit case for filing appeal. In this case also, he said not fit for.
My submission, that is not a circumstance to be considered. What is to be considered is what was the findings in the criminal court here, merely because the accused turned hostile in this case. He was acquitted.
No, but see, when the complaint court has given verdict.
No, that's what I am submitting.
One submission, one submission in this case.
Wait, my friend, I am arguing.
Petitioner not put on trial. No criminal trial is conducted in this case.
Yes. Back to page 37. Page 37, 38, just read. Come back to para 7. Page 38, para 7.
Yes. Yes. Examination of internal matter and taking into consideration the accused subordinate flight officer, the police department to order drop further action against the Naishwaro. This formally it whether the allegations of corruption as well as the allegations of non-sufficient manpower duly acknowledging from the charges since the charges were not well proved by the time of a dismissal proceeding. Yes.
But tribunal proceedings also in fact exonerated. Court also in fact exonerated.
The tribunal for disciplinary proceedings is not there because inartfully test was held.
That was native.
Report was submitted that is.
Until case trial. Why is singled out? Petitioner is singled out from all other.
So it's not a question of petitioner being singled out. Merely because petitioners, it is not the same incident, others were given benefit, and these are two different incidents. Not that
the facts, in fact, the.
No, my submission is that in this case, he filed 2 or 3 GOs where it is treated as on duty. There may be other cases where it's not treated as on duty.
You are not. See, in fact, if you see, you just read the counter.
Yes.
See, in the repetition, he has stated all this. The counter is completely silent on those aspects. If there was, in fact, there was some difference, I'll say there were different the grounds for continuing their service or taking their suspension period as continued service. You are not explaining anything. The counter nothing. You can't in fact improve on your counter. Counter is completely silent.
Except what order stated.
Completely silent. Not even referred to. So in fact, there is some disparity. Or say this impact is the basis. More impact. Say
No,
nothing is
that,
not part.
with reference to that aspect, I know counter is silent on that aspect. One other technical objection is that this first order of rejection is of 2013. In fact, thereafter, once in 2012 order is passed by the government, then therefore he can file a review because it is not a first order is of 2012.
That is also not there in the counter. Counter, yeah, that also.
No, that is a legal aspect. When he cannot go on making representations after representations and thereby extending the limitation to file OA before the tribunal. Come to the court in 2015.
Yes.
The rejection order is 28/3/2013. Once that is made, there is no other provision to file again representations before the government. Once government rejected it, lower authority rejected it, there is a provision for appeal and revision. Once the government passes an order, he again files a petition that was again rejected on 13/5/2014.
Yes.
Then he again makes a representation. When that is rejected, saying that it is already twice rejected, therefore it cannot be considered. By challenging that order, he also challenges the earlier orders. Under Section 21 of the AP Administrative Tribunals Act, an order has to be challenged within 1 year. In the case of challenging order of 2015, he cannot challenge the earlier orders. 2015 order is not accepted. Page 50.
No, in fact, this page 46 to the review. The review has been filed.
So this first order is of 42, my lord.
Yes.
His request was rejected.
He filed review.
The question of review doesn't arise, my lord, in this case, because this order itself is on review. Earlier order itself is of government. The 2012 order exonerating him, page 37 to 38. In this action is dropped, duty exonerating him since the charges were. Therefore, he made an application
Page
to take the period as on duty.
Page 42.
That was rejected at page 42.
Yes.
Once the order is passed by the government itself, even assuming there is a review, that order is passed on 13/5/2014.
Yes. Thereafter, he filed next year.
Thereafter, he filed another application, which is not maintainable. There is no statutory provision for making applications after applications.
But anyway, he has filed within 1 year. He has filed after the review.
This is rejected at page 50,
Yes.
saying that this is already rejected, therefore it cannot be entertained. My submission is not this. There is no illegality in passing this order of dated page 50 order. By challenging this, you cannot challenge the earlier orders beyond the limitation period.
That's one new point.
On submission.
Yes, please.
The citation filed by the GP regarding to the criminal case admitted by the court in a TSHC case. But in my case, Your Lordship, the petitioner was not put on trial, nor any charge sheet is filed. This citation and law later in this case is not applicable. The factions are of my case. And further, I have found the anti-contracture case, Your Lordship. The Honorable Supreme Court of India. Page number 27, Your Lordship. Page 27. Now the citation was passed with regard to the powers invoked by the High Courts under Section 482 CRPC. Meanwhile, the Honorable Supreme Court, para number 47, while considering When considering
Para 47.
21.4, page number 27. 1.4.
Yes.
Your Lordship, while considering the importance of the reasons to be given during the decision-making process, in the case of Kranti Associates Private Limited versus Masood Ahmed 2010, 9 SCC 496, in paragraph 47, the court has summarized as under. Summarizing the above discussion, this court holds in India, the judicial trend has always been to record reasons even in administrative decisions if such decision affect anyone's prejudice. A quasi-judicial authority must record reasons in support of its conclusions. Insistence on recording of reasons is meant to serve the wider principle of justice, that justice must not only be done, it must also appear to be done accurately. Recording of reasons also operate as a valid restraint on any possible arbitrary exercise of judicial and quasi-judicial or even administrative power. Reasons reassure that discretion has been exercised by the decision maker on relevant grounds and by disregarding extraneous considerations. Reasons have virtually become as indispensable a component of a decision-making process as observing principles of natural justice by judicial, quasi-judicial, and even by administrative bodies.
Yes.
Reasons facilitate the process of judicial review by superior.
That's fine.
One more submission.
Yes.
Lordship, the council raised an objection for the first time before this honorable court, ignoring it counter also, saying that the review petition is not maintainable. Lordship, it is a settled principle of law that the objection raised in earlier point of time, raised the first time before the court, is not sustainable. Moreover, the order itself speaks that this order is not maintainable for filing it under the caption of review. They are saying that the representative entire matter hereby reject the request of the individual since the request was earlier rejected twice. My humble submission, Your Lordship, can kindly come to page number 61, Your Lordship. This is the case. Para number 3, Your Lordship, in the reference 61. The reference second read above, the investigation agency in the final report has stated that evidence is not sufficient to prove the demand and acceptance of illegal gratification of rupees 3 lakhs. At the time of 2012, 3 lakhs is a very big amount. The case of the petitioner therein was considered under the same rules 54(3)(b), treating his suspension period as on duty, whereas in my case, no, I have not received any bribe. There is no evidence, no charge sheet is filed, I was not put on trial, and the competent authority, that is GDP, has exonerated me honorably by giving its findings. The findings were accepted by the government in first order, and subsequently raising these kind of issues, Your Honor, which are not maintained. Next, in the light of I pass the judgment of Honorable High Court, the petition is entitled and most humbly submit this.
What is the judgment?
WP number 219 particular office 117. In Manikadu, the office open. Similar circumstances.
That judgment is on different. The report 54.
No, I think you are referring to 2011 8 ACC 155.
Judgment related on my friend Honorable Justice Nanda's order.
Yes.
There, it's a provision in 54. Yeah. 54 and
54B. 54B also in fact will refer.
Refer to, but there may not the direction is.
To not interfere in the last. I have not completed. Submission.
No, in fact, I only asked him what is judgment in fact. Yes.
My submission, in this judgment also there are similar circumstances. The Honorable Court clearly pointed out under para number 20 of the judgment, Your Lordship, page number 27. This court opens that in similar circumstances, order have been passed by GORT number 1238 dated 18/5/23 and by GORT number 1268 dated 25/23, treating the period of suspension in the said cases as on duty under fundamental 54B4 by the third respondent here. However, no relief has been given to the petitioner herein, though the government has set aside the punishment of PPA for 1 year with effect imposed against the petitioner. GORT number so and so.
This point you all
applicable.
Only this 2011 ACC 155 you referring.
That may not the court, though there is acquittal in criminal case. Court said may not whether circumstance justify the suspension as on date of suspension. Not because subsequent events of exoneration. In that case, not in criminal case was acquitted. Court said merely because he was acquitted, it cannot be said that he should be treated as on duty. Similarly, may not here merely because he was dropped of the charges.
Yes, sir. Outpunch Yes.
Initially appointed as senior assistant, then further promoted to the post of senior assistant. This petition is distributed approved by the showcase notice wherein to revise the seniority list, which is settled long back, year 2011.
The implications are not. What about implication? Who has filed implication?
Increed petition, file my counter, in fact, he is no way, is no locus to increed Millard, he belongs to other zone Millard, I belongs to S1 zone 5. They belongs to S1 zone 6. But the post of superintendent is a zonal post Millard, which is no way connected to Millard. The reason best known to the unemployed increed respondent Millard, they approached the Honorable Court Millard. I filed my counter Millard opposing the increment of the person.
Yes.
But the Millard petitioner is currently working as office superintendent Millard.
What about contempt?
Contempt Millard, this Honorable Court suspended the showcase notice. Millard, for not implementing the same Millard, the petitioner filed contempt petition. After filing contempt Millard, they filed counter Millard along with the proceedings that Millard, they are not Millard revising the seniority list. At the stage Millard, that is pending Millard. Now Millard, after filing that counter, now they are reviewed the seniority. In spite of pending contempt Millard, they are reviewed the seniority. I will stop with that Millard. That is why Millard contempt is not closed Millard at the point of time.
I'm still.
Yes, Millard. Still survives Millard. I will establish Millard. They complete
petition is substitutable, then contempt will arise.
Yes, that's.
Yes.
Millard, the petitioner was initially appointed as Millard junior assistant Millard in 9/11/1993 Millard. Was further promoted to the post of senior assistant on 26/8/2003.
First he was appointed as
junior assistant Millard. Junior assistant on 9/11/1993. And further promoted to the post of senior assistant on 26/8/2023. So 2003, 26/8/2003. Millard, why things could that Millard? The respondents Millard communicated the seniority list Millard, final seniority list of senior assistant Millard, working in the Millard, second respondent organization Millard. Initially Millard, they are issued a provisional seniority list Millard, call for objections Millard. After Millard, considering the objection, they are issued final seniority list page 20 Millard. Provisional seniority list of senior assistants communicated. Certain objections received, rectified to seniority list. Final seniority list communicated regarding. This is Millard White order 3699/G1/2011, dated 8 February 2011. The seniority list is finalized by the Commissioner Millard, by the Vidhana Parishad Millard, the second respondent here. The seniority list issued by the second respondent is become final. Millard, after lapse of Millard, 5 years Millard, the unofficial respondents here in Millard, page 32. Page 33 Millard, page 33. Millard, the unofficial respondent Millard, after finalizing the seniority list in the year 2011, they submitted a representation Millard, to revise their seniority list, placing their names over and above the petitioner. The same was rejected by the Commissioner Millard, the same second respondent here. That is page number 33 Millard.
senior assistant to promotion 25 Act 2003. Is 32.
Page 33, Milord. Page
32 is the representation. 30, what is 32?
32, Milord, they call for service particulars, Milord, for effecting promotion to the post of superintendent, Milord. 6/6/2016, Milord, they call for service particulars of the eligible persons, Milord, to consider the age for promotion, next higher promotion. Milord, in the meantime, Milord, page 33, the unofficial respondents hearing submitted a representation to Milord after 5 years to revise their seniority and place their names over and above the petitioner. The same was rejected by the Commissioner, Milord. 1/7/2016. Milord, I read the Milord that order, Milord. With reference to the subject cited, Sri Ahmad Hussain, Senior Assistant Office of BCHS, Karimnagar, has requested by reference that cited to rectify his seniority and issue revised seniority list by placing his name above Sri P. Nagaraju and Sri P. Sudeep. The Commissioner APVVP Hyderabad has issued provisional seniority list by reference first cited as follows. That is Milord 7/8/2011. Milord, the placement of Milord, further the Commissioner APVP Hyderabad has revised after examination of the objection submitted by Sri P. Nagaraju and issued final seniority list by reference cited as follows. Milord, this is seniority list. Milord. Further, it is informed that serial number 1 to 5 except serial number 4 were promoted in the panel year 2011-12, 12-13, and the seniority list is in force. In view of the above, his request is rejected and final seniority in force taking into account. The Commissioner himself, Milord, stated that the seniority list is already finalized in the year 2011 and promotions were effected by following that seniority. Hence, the claim cannot be considered for reason of seniority. But while things stood thus, Milord, now all of a sudden, Milord, by considering their representation, entertaining the representation of the unofficial respondents, page 12, Milord, the second respondent himself, Milord, once he finalizes seniority, Milord, he has no power and authority to revise the seniority. If they want to revise, Milord, government alone is competent authority, higher authority to revise the seniority list. Now, the second respondent issued a show cause notice, Milord, dated 21/2017. I'll read the show cause notice, Milord.
Yes.
With reference to the subject cited, the senior assistant final seniority list has been communicated to the individuals by Commissioner APVVP Hyderabad, while letter dated 8/12/2011. The same has been once again communicated by reference first cited. Accordingly, the following senior assistants have requested by reference third and fourth cited to rectify the seniority as per RDM and HS Warangal, parent department seniority by reference fifth cited. Sri Ahmad Hussain, Senior Assistant Superintendent District Headquarters Hospital, Jagityal. P. Sudhir, Senior Assistant Officer of the District Hospital, Karimnagar. Further, it is to inform that seniority of the above individuals has already been fixed as follows. Milord, himself, Milord, revising the seniority even prior to issuing a show cause notice. Milord, Ahmad Hussain 11, Sudhir 10, Milord, Sri Nagaraju 9. Further, it is to inform that the employees who are observed into VVP hereinafter, their service will be governed by TVVP Special Service Regulation 2000. As per GMS number 48 dated 29/1/2000, their seniority will be protected as per their parent department seniority only. Accordingly, the department has issued absorption orders. As such, the Nagaraju, Senior Assistant, Office of the Superintendent District Headquarters of Karimnagar is directed to submit his explanation within 15 days as to why not revise the final seniority list as per his parent department seniority. He issued the same authority, Milord, issued a show cause notice after Milord more than 6 years. Milord, my respectful submission before the honorable court is that, Milord, once the commissioner who is competent authority finalizes seniority list, Milord, is no power and authority to Milord alter the seniority list. If they want to alter, if they are aggrieved by the seniority list,
and with their placement in the seniority list, as per Rule 26 of State and Subordinate Service Rules, they have to approach the Millard competent authority within 90 days. Value 2 of the value. Page 139.
Yes.
226 Millard appeal against seniority other conditions of service. Except where otherwise provided in the rules or special rules, an appeal shall lie against an order of fixing the seniority of a person or affecting any conditions of service passed by the appointing authority to the authority to whom an appeal would lie against an order of dismissal passed against the member of service, class or category. The powers of sub-rule A shall be exercised by the head of the department if he is not the appointed authority or by the state government or its own motion, or an appeal received by the head of the department or the state government, as the case may be. The appellate authority, if it is not the head of the department or the government, shall dispose of such appeal within a maximum period of 1 year. If the appeal has not been disposed of within the aforesaid period, the head of the department or the state government may intervene in the matter for sufficient reason to be recorded in writing and take such action as may be considered necessary by them in the matter. No appeal for restoration of seniority or assignment of notional seniority on par with this junior shall be entertained by the appellate authority after a period of 90 days from the date of on which junior was promoted. After 90 days, the seniority, they cannot entertain any representation.
Say that after period of 90 days from the date on which junior was promoted.
The appeal against seniority and other conditions of service,
Who is applying authority?
Government, the commissioner is the prepared seniority list, and in fact, is rejected their case, stating that they after lapse of time, that cannot. In fact, similar issues, number of issues considered for consideration, various courts, government issued a circular memo, page 40, can you consider as final?
See this case, page 34 is a final list. Page 34,
Page
34.
Final seniority list is page 20. Final seniority list in the cadre of senior assistants.
2011.
2011.
What is this page 33, 34?
Page
33, 34. What is 33?
Page 32. This is with regard to affecting promotions. They are called for service particulars. Page 32. Lower 11.
32, 34.
33. Now they are earlier. They made a representation in the year 2016 to revise their seniority list and place their names over and above the petitioner.
Yes.
The commissioner considered and rejected their case, stating that already final seniority list was finalized, and by following that seniority, promotions are affected.
Yes.
With regard to seniority and other conditions of service, number of cases the consideration before the
33, that's for both are same.
Yes, but they both are same. That only need copy page 40.
Once a commissioner, in fact, even if is already rejected.
Yes, Millard.
Then why again there was one more
Yes,
proceeding in
extraneous consideration, Millard. Once he is rejected, stating that cannot be revised. After 1 year, Millard, same authority by entertaining their representation, Millard, they are issued they want to revise the seniority in favor of the annexal respondents. Millard, in fact, similar issues, Millard, number of cases, Millard, with regard to the alteration of seniority come up for consideration before the Honorable Apex Court. On the Honorable, basing on the Honorable Apex Court judgment, government issued memo, page 40,
40.
sir, page 40.
Yes.
That relevant parameter and relevant parameter.
Yes.
Para 4 of the circular.
Yes.
While the rule position is as stated above, in several cases, the appeal petition is filed after completion of several years after the junior promoted to the next higher category with a request to revise the seniority. In this context, the judicial pronouncement, the Supreme Court of India ruling on seniority in service matters published in the in 1992 SEC 523 is extracted below. During the entire period of more than a decade, they were all along treating the as junior to the other aforesaid person, and the rights interested had crystallized, which ought not to have been reopened after the lapse of such long period. At every stage, others were promoted before B.S. Bajwa and B.D. Gupta right from the beginning, as found by the division bench itself. It is well settled that in service matters, the question of seniority should not be reopened in such a situation after lapse of a reasonable period because that results in disturbing the settled position, which is not justifiable. There was inordinate delay in present case in the present case for making such grievance. This alone was sufficient to decline interference under Article 230 and to reject the petition. Government directed that in dealing with the cases for fixing the seniority, the procedure and the rule prescribed in Andhra Pradesh State and Subordinate Service Rules, in the special rules governing the post shall be followed. No request for revision of seniority for a period which is more than 3 years old shall be considered. The seniority list in each category shall be communicated, and as and when the employee completes the prescribed period of probation in the respective category. The Honorable Supreme Court held that by virtue of reason of seniority.
But now, if you read paragraph 5, no request for revision of seniority for the period which is more than 3 years old shall be considered. Then this will go against Rule 26.
Shall not be considered,
But say
that
means that below 3 years it has to be considered.
That purport of that circular that cannot be considered after 3 years.
But here it's only 90 days. As per rule, only 90 days.
90 days. Even reasonable time for any mistake, if they committed any mistake, even there is administrative lapses that cannot be considered after lapse of 3 years. The judgment Bajwa Supreme Court judgment that issuing that further further issuing of circular the judgment is the relevant portion para 6 in that case also after lapse of obviously on this conclusion alone the judge should have gained dismissal by setting aside the judgment of the single judge, allowing the LPA without any caveat. However, the division bench after reaching the above conclusion proceeded to grant the benefit of much earlier date, namely 6/4/1964 as the date of appointment on the list of concession of the additional advocate general, where therein without considering the effect of this same taking into account the inconsistency with its earlier finding. We have no doubt that the concession on this point being one of law, it cannot bind the state, and therefore it was open to the state to withdraw as it has been done by filing a review petition in High Court itself. That apart from that concession made on behalf of the state cannot bind itself. That apart from the concession binding DP Baja and Changer Singh or anyone else who would be adversely affected by it. Those persons therefore have an independent right to assail the view taken by the reasoner. It is with regard to this part of the judgment of which we say that even though the LPA is said to have been allowed, but it has the effect and in reality of being dismissed because it grants certain benefits to B.S. Bajwa and B.D. Gupta, who are the respondents therein. Having heard both sides, we are satisfied that the petition was wrongly entertained and allowed by single judge, and therefore the judgment of the Honorable Single Judge and the Honorable Division Bench have both to be set aside. The undisputed facts appearing from the record are alone sufficient to dismiss the petition on the ground of laches because the grievance made by B.S. Bajwa and B.D. Gupta only in 1984, which was long after they had entered the department in 1971-72. During this entire period, for more than a decade, they were all along treated as juniors to the other opposite persons, and their rights inter se had crystallized, which ought not to have been reopened after lapse of such a long period. At every stage, others were promoted before B.S. Bajwa, B.D. Gupta, and this position was known to B.S. Bajwa and B.D. Gupta right from the beginning, as found by the division bench itself. It is well settled that in several matters, the question of seniority should not be reopened in such a situation after the lapse of a reasonable period, because the results in disturbing the settled position, which is not justifiable. There was an inordinate delay in the present case for making such a grievance. This alone was sufficient to decline interference under Article 226 to reject the petition.
Yes.
By following the judgment of the Honorable Apex Court, government issued that circular to not to entertain the not to revise the seniority or this after lapse of 3 years.
Yes.
One more, the respondent Anushka, some two persons will file a impeach petition. I am opposing I filed counter opposing that impeach petition. In that, by following this same circular, the respondents rejected the claim of some individuals for revision of the seniority. Now they contrary to that, they stands now in the counter stating that they are entitled to review the seniority. I filed the counter affidavit on 23.
Yes.
Even 23 I counter is the impeach petitions.
Yes.
Page 13 of the
Page
13.
13.
Last but one paragraph. In that case, also they start revision of seniority. The same was rejected by the same second respondent commissioner.
Yes.
But further it is I read two times. Further it is also informed that as per the circular memo dated 25/2004, government has issued instructions that while dealing the case of fixing the seniority, the procedure and the rules described in AP state and subordinate service rules or special rules governing the post shall be followed. No request for revision of seniority for a period of which is more than 3 years old shall be considered. The seniority list in each category shall be communicated as and when the employee completes the prescribed period of probation in the respective category. In view of the circumstances explained above, it is not feasible to include the name of the individual in the seniority list of senior assistant of Zone 6 as per circular memo dated 25/2004. Hence, the request of the individual cannot be considered at this juncture. Likewise, another person request also rejected by the authority, second respondent. Next page 15.
Yes.
page 15, the last part one paragraph. Further, it is informed that as per the circular memo dated so and so, no request for revision of seniority for a period which is more than 3 years old shall be considered as the seniority list was communicated in the year 2018. Hence, the request of the above senior assistant considered and rejected in terms of circular memo.
Yes.
Moreover, by implementing the interim orders, they issued a memo stating that they are not going to be revise the seniority. Now, contrary to that, I filed that one proceedings. They decided to revise the seniority list. Pending expedition. I showed the article. With regard to one of the objection of my friend is the show against show cause notice petition is not maintainable. In normal circumstances, that's correct. Show cause notice, they have to file the explanation, explaining the reasons. But in this case, they are already decided to revise the seniority list. To a post-decisional, in that regard, I am relying on judgment of the Honorable Supreme Court. Last part of this, para 12 line, 22 paras, with regard to the in this case also, they are issued a circular for implementation. They are seeking this explanation, but they are already decided to implement. In that case, Honorable Apex Court held that no purpose will solve if, by submitting his explanation.
Yes.
Para 12, it is however contended on behalf of the CORIL that after the improved circular was issued, an opportunity of hearing was given to the employee with regard to the alterations made in the conditions of their service by the improved circular. In our opinion, the post-decisional opportunity of hearing does not subserve the rules of natural justice. The authority who embarks upon a post-decisional hearing will naturally proceed with a closed mind, and there is hardly any chance of getting a proper consideration of the representation at such a post-decisional opportunity. In this connection, we may refer to a recent decision of the court in KL Shipyard versus Union of India. What happened in that case was that the Hindustan Commercial Bank, the Bank of Cochin, and the Lakshmi Commercial Bank, which was private banks, were amalgamated with Punjab National Bank, Canara Bank, and State Bank of India, respectively, in terms of separate schemes drawn under Section 45 of the Bank Regulation Act 1949. Pursuant to the schemes, certain employees of the first mentioned three banks were excluded from employment, and their services were not taken over by the respective transfer banks. Such exclusion was made without giving the employees whose services were terminated an opportunity of being heard. We may now point out that the learned single judge of the Kerala High Court had proposed a post-amalgamation hearing to meet the situation, but that has been vacated by the division bench. For the reasons we have indicated, there is no justification to think of a post-decisional hearing. On the other hand, the normal rule should apply. It was also contended on the behalf of the respondent that the excluded employees could now represent then the case could be examined. We do not think that would meet the ends of justice. They have already been thrown out of employment and having been deprived of livelihood, they must be facing serious difficulties. There is no justification to throw them out of employment, and they given them an opportunity of representation when the requirement is that they should have the opportunity, referring to avoid above as conditional precedent to action. It is common experiment that once a decision has been taken, there is a tendency to uphold it, and a representation may not really yield any fruitful purpose. That in view of that has been taken, the view has taken by this court in the above observations is that once a decision has been taken, there is a tendency to uphold it, and a representation may not yield any fruitful purpose. Thus, even if an hearing was given to the employee after the issuance of the improved circular, that would not by any compliance with the rules of natural justice or avoid the mischief of arbitrariness as contemplated by Article 14 of the Constitution. The High Court in our view was perfectly justified in quashing the improved circular. But in this case also, Millard, second respondents in the year 2016 rejected the case of the actual respondent for reason of seniority. After 1 year, Millard himself entertained the representation and issuing a show cause notice. This is highly illegal. There is a pre-edition. Millard, by giving Millard a note reply, the purpose will not solve. Millard, in the same Millard, the show cause notice issued by the second respondent is Millard arbitrary and Millard even without power and authority and contrary to the rules. That is my supposition.
Before any goes start, I will.
Yeah.
I'm the unofficial respondent.
No, lettings are there. Your applications are pending.
No. I'm not in mid application. They have made. I'm a.
As per number 3 and 4.
We are officially noticed.
3 and 4.
Document kindly see the finally additional update matter. September matter. The document kindly see my additional update.
Date? 9
Yes, ma'am.
19 2017.
2020 September. The leave of report only I filed. Additional update filed by respondent number 3 and 4.
31/8/2023.
Yes.
Yes.
We wrote in page 2, you wrote kindly see. This is the initial entry when as a junior assistant in the department. Ahmed Hussain, 6/10/1993.
Yes.
And second Miller P. Sudhir, 30/10/1993 as a junior assistant. Now writ petition 9/11/1993. Let's got it, man.
Yes.
Page 2 minute. Additional of
Para?
Para 2. Tablet color. Ahmed Hussain, appointed as a junior assistant on 6/10/1993.
There is a count of file by him.
Minor.
You got a top section of this? Not there in this one.
Sort to the minor.
Not there in this one.
Minor, it will have taken from one. That's important. Yes.
1/8/1993. 1/8/1993. So, this is fine.
RLC. I stated two dates, then if a lot not satisfied, it will take note. You're also kindly similar. It's junior to the
yes.
My clients. R3 and R4 are the senior to the petitioner in appointing as a junior assistant. The third respondent was as a 6/10/1993 as a junior assistant, and fourth respondent 30/10/1993. Whereas the revision petition, this writ petition was 9/11/1993 as a junior assistant.
Yes.
So respondents are senior to the petitioner. Next, you will also be considered they are further promoted as a senior assistant on 25/8/2003.
Yes.
In the said promotion list also, my lord, the writ petition serial number is 287.
Yes.
My client's serial number is 284 and 286. In junior assistant, we are the senior. In the senior assistant also, we are the senior. My lord, you will also be considered my vacant stay petition. You will also be considered.
Yes.
850 you will also be considered. This is my promotion as a senior assistant.
25/8/2003.
Yes, ma'am. 25/8/2000. Second para, consequent to the promotion to the post of senior assistant, they are posted to the place of mention against their name as follows. Column number 3, I decided in this one. So, that is the one, Ahmed Hussain.
Yes.
Then we will also be sent to the next page. This is crucial. Para 2.
Yes.
They are informed that they should report the place of posting within 15 days.
Yes.
So, as per this promotion period, I am the senior. And though he has reported one day before or not, that will not give any impact. I have given a 15 days time.
Yes.
So I am saying next you will also kindly see page 53. Initially, madam, we are all director of health employees, madam. We are absorbed in the Vaidya Vidhana Parishad. Page 53.
Yes.
Subject matter, the special regulation to the final absorption of employees to the AP Vaidya Vidhana Parishad instructions. In order to build up own cadre in AP Vaidya Vidhana Parishad, government issued an amendment to the Act 29 to authorize the Commissioner of Legal for option from the interested deputation, interested employee working the director of health. A paper publication was issued to that effect. Options were received from the interested employee. After verification and scrutiny, it is decided to absorb the services of employees shown in action duly following the guidelines issued by the government from time. Accordingly, their services are hereby absorbed into AP Vaidya Vidhana Parishad with immediate effect, and herein after services will be governed by AP Vaidya Vidhana Parishad. Special service regulations also, and their seniority will be as per seniority in their parent department. This is crucial matter. Vaidya Vidhana Parishad petitioner and respondents were absorbed on 11/12/2008.
Yes.
It is not the case that he is a senior. He is junior to the respondents herein. In the junior assistant as a senior assistant. But how he has become the senior, how the seniority list has become, God knows. And another submission, Millard, you also can see. In the year 2011, Millard, that seniority list was not communicable. And after bifurcation, Millard, Telangana government formation, Millard, 2016, the final seniority list was given. In the said final seniority list, Millard, there was some discrepancy were taken place. The respondents were shown as a junior to the petitioner. Then we are given a representation. By representation, they issued a show cause notice. He is not stating how he is a senior. Only saying is the seniority cannot be disturbed, seniority cannot be disturbed. As specifically stated in the 2011, they were not communicated at any point of time. Then you also candidate a show cause notice. What prevented him to give any explanation by saying all those things? Then I am relying a Supreme Court judgment for that. 2004, 3 SEC Millard. Headnotes your maintainability, alternative remedy, exhaustion remedy, writ against show cause notice issued by the statutory functionary for violation of the provisions of relevant acts para and pyramid. Unless the High Court is satisfied of the nullity of the show cause notice for want of jurisdiction of authority concerned to even investigate the fact, and writ petition challenging the show cause notice should not be entertained as a matter of routine. Writ petition should rather be directed to respond to the notice, whether the notice was found on any legal premises is a jurisdictional issue and can be initially adjudicated by the authority issuing the notice. Administrative law, natural justice, and other sources. Next, you will also kindly see the 441 page, the held portion, third paragraph. Partly allowing appeal, Supreme Court has held. Unless the High Court is satisfied, you have got it. Next page 441.
Yes.
Unless the High Court is satisfied that show cause notice was totally non-est in the eye of law for absolute want of jurisdiction of the authority to even investigate into fact, writ petition should not be entertained for the mere asking investigate into fact. Writ petition should not be entertained for the mere asking and as a matter of routine, and a writ petition should invariably be directed to respond to the show cause notice and take all stands highlighted. And the writ petition, whether show cause notice was founded any legal premise size, is a jurisdiction issue which can be argued by the recipient notice, and such issues also can be adjudicated by the authority issuing the very notice initially. Before agreed could approach the court. Further, when the court passes any interim order, it should be careful to see that statutory functions specially and specifically constituted for the purpose of not denominated power and authority to initially decide the matter. Para 5, you will also find this. 443. Para 5, 443 page. This court in large number of cases has deprecated the practice of High Court entertaining a writ petition, questioning the legality of the show cause notices, calling the inquiries as proposed and retarding investigating process to final actual trial with participation and in presence of the parties. Unless the High Court is satisfied that the show cause notice was totally honest in the eye of law for absolute want of jurisdiction of the authority to even investigate it. Writ petition should not be entertained for the mere asking and as a matter of routine, and the writ petition should invariably be directed to respond to the show cause notice and all as highlighted in the writ petition. Whether the show cause notice was found in legal principle, the judicial issue which can be argued by this notice. The court passes the inform order. It should be careful to see that well, my submission but is only show cause notice. And moreover, he is a junior. Let him say, my lord, he is a senior to my clients. Then he has a case. My content is in 2011 seniority was not communicated. The 2016 this was communicated. The moment we give an invitation. So my submission, my lord, here on the technical notes, my writ petitioner wanted to state this case, but he is a junior to in his junior assistant and a senior assistant cadre, and no promotion was given here. While pending the writ petition, all the 3 candidates were promoted as superintendent. This is not the case that because of seniority was revised, he was affected, or some other, nobody was affected. Senior assistant was given in the year 2008. The subsequent no promotions. While pending the writ petition, all the petitioner and respondents are promoted. This is, and this is not the case that we mere by revising senior somebody was affected. So my submission is only show cause notice. He has to submit explanation and invert the order. So premature. He has to be liable to be dismissed.
Yes.
While the Indian petition we had year 1 of 2022. One number was 560.
Are you affected? According to them, you are zone. They are zone 6. You are zone 5.
Yes. Process then mentioned.
Whatever, let him keep your argument, then we'll see.
In fact, the trading petitions concerned, absolutely even our counter is the journal. There is no link between there is my counter might be very clear. That is with regard to the promotion. This is the 15 seniority zone 5.
Response number 2.
Response number 2.
Yes.
There are 6 here for whether what was happened. Well, this was the problem actually. While they are observing in the erstwhile APVP and subsequent to their observation, there was a condition of service rules that is 33A. Whoever observed in the their service welfare and from the parent department to be protected. So there is no dispute about the appointment as well as the posting of the work. That's it.
Response 3 and 4.
The petition. As far as the CC is concerned, absolutely they already promoted. That's why my friend has stated we are not pressing the CC. That's why we did not do it. But as far as the WP is concerned, now this is the journal person is concerned. Now, period number 7, what was happened? The records were with the ABVP. This was proper happened. Some disputed some orders were issued by your side that that is now in period number 7 of my council. Why the so-called necessary and warranted to? Yes, sir. I respect the subject. It is true that the second response issued so-called notice by 21 to the petitioner as well as the response. The provisional list of the seniorities has been prepared in the year 2013. No further final seniority has been prepared after that in the year 16, after bifurcation of the state of Telangana. The Commission of Telangana has communicated to the petitioner and unofficial respondent. The final seniority list of the senior residents prepared in the year 2000 by oversight, as the original files were retained by the commissioner by the appointed. Unaware of the provisional seniority list of the senior states prepared in the year 2013, the 2011 list was sent in the state of the further, the respondent has issued a so-called notice to petitioner as per the Rule 24B of the Telangana State Government. The state government at all the events shall hand out the power to revise in any manner they consider suitable in the for promotion to any category class that is less than 7%. The aforesaid power of given them by the state government could be exercised by the respect of the honor under the department by the hence the petition cannot be considered as a junior. Next comes to the under page, which is very clear. So there is the submitted the response have been shown. Upper question, this is the shown that is a senior to the petitioners. According to the parent department senior correctly, provisional list of the seniors in the year 2000. That was they are above or to the petition. It is submitted as per the category to the highest court to the promotion within the period of 6 months from the date of the can be appealed to lie against the order of dismissal or pass against the member of service. The class or category the division may be made by the operator of the approach either by own motion or appeal by the member of the class category promoted to the highest. In this, the rule does not apply to the petition in the better category and not promoted the next category officer. But it is considered for the rule no appeal to his petition or they should and it is from the data and this black it was promoted was in the instructed promotion calculation are promoted higher category. Here the start of the department. Once they observed that was a rule 33 A of the sovereign service rules. Ultimately, the department has to protect the interest of the service of the parent department. If that can be taken, they will be the senior. Then the petition. Because of the files were not between and instead of the unaware of by oversight the issue and
is the commissioner because of his one letter, so many.
The commission has the power to vested power to use to revise it wherever that we should mention in the.
Because of mistake of one commissioner when so many litigation, then yes.
That was the start mistake of that. Because the list was what this was probably arose this because the files were not set by the rest of the VVP and we issued that.
But the subsequent there was clarified, you not clarified those. This was 2011 was sent mistake. Nothing was in final.
No, the government has to do again press proposal. I mentioned it in my.
You say, but
in my parent number yes.
But
parent
when
number 5 I clearly mentioned it. In parent number 5 my count.
No, when did the commissioner realize that there was a mistake?
This was the parent number 5 minutes.
Yes.
The second respondent has request the district order hospital kind calling for the service of particular petition so it is still the same was submitted. Further it is submitted. The selection committee meeting was held and so there was the selection the promotion post service and there are some objections raised by the grant code stating that there is seniority to be rectified for the parent department. And seniority the respect was directed the selection committee to submit fresh proposals to addressing to the operations raised by the officer as well. Therefore, this was the so-called notice issued.
It was not issued, but 2011. In fact, he was communicated.
We admitted in the counter that.
When did commissioner realize that there was a mistake committed by her? Whether any communication was given that in fact ignore that 2011 and 2013 in fact this is correct.
Yes.
Only after filing.
Yes.
That was not communicated. 2011 not communicated.
Yes.
One more small. My endpoint relied on 1992 SEC. It is in fact in my favor. It's in my favor. The seniority dispute raised after more than a decade after gaining service when the meantime promotions had also taken place. No promotion was taken place. It is not a decade case. The moment we came to know, we have given a representation. That's my thought.
In fact, the standing council to develop the case, now they are the seniority list was prepared by the then state of Andhra, combined state that is 8/12/2011, state of AP Now he is stating that records are misplaced. That's not correct. To develop the case, now they are entertaining all these things. One more show cause notice, normal circumstances against show cause notice, we cannot approach the Honorable High Court. But in this case, the same authority rejected the case. After 1 year, same authority entertaining and issuing a show cause notice. That is bad. This Honorable Court.
Whether the commissioner has review power? No.
If they have committed any mistake, government alone, government is competent authority to rectify the mistake. In fact, I also submitted my explanation. Having submitted explanation, for the injustice caused to me, I approached this Honorable Court. I submitted my explanation immediately on 1/3/2017 to the show cause notice. Along with the petition, I filed page 35.
Yes.
I submitted a detailed explanation. They are slept over since 2011. Since 2017, they wake up and submitted a representation that is cannot be permissible.
What about contention that
initially they are appointed in direct appearance. Subsequently they are promoted as senior assistants on the same day. But the petitioner joined in prior to the unofficial respondents. Even assuming that my seniority is wrong, now they are prohibited for revised seniority after long lapse of time. Now they are stating that their seniority list is not communicated. This is not at all correct. The same commissioner considered the request and rejected. At this stage, the commissioner is no power and authority. He is incompetent to revise the seniority list. That is my submission.
Additional affidavit WPUS sir.
89389, my lord. I filed an additional affidavit, my lord. On 12/9/2023, WP USR 89389 of 2023. Filed on 12/9/2023.
What about this the proceedings of commissioner where in fact the list was revised and then your recommendation was rejected? What about rejection? You are saying that it was a mistake only.
Yes,
Then how the commissioner has in fact rejected their recommendation and then confirmed that
after objection, then the selection committee was held and
proceed. Even at that time she was not, she did not realize. She rejected the recommendation, then finalized this where the petitioner was given a senior.
the counter we admitted that one, but commission had power to because on the basis of
How can you review? The commission can review. I won't.
With taking permission from the government, my lord, they can.
Where is the permission?
My lord, that is the internal communication, my lord. You may kindly see. And moreover, my lord, ultimately we are the seniors, my lord.
Correct, but when they have taken conviction, that should have been filed before along with the count that he has taken permission, also approval of the government, competent authority.
Cannot be permissible, my lord. Taking permission behind my back.
That is the case, my lord. Fraud vitiates everything. I can.
Who has committed?
My lord, at the instance of repetition only this was taken place. I can say.
You also give a recommendation. You also give a recommendation.
That's true, my lord.
Who has done? Who has committed fraud? Then now he has to then commissioner has committed fraud.
But who has been fraud has taken place?
If you take your word, then commissioner has committed fraud.
But I have not stated. My learned friend said extraneous consideration. You might have influenced that. That's why this was. I have not stated that.
No.
My learned friend, especially from the beginning, he has stated that for extraneous consideration this was done.
The context is that when he has revised and then she has rejected your recommendation, why she has so motto revised?
But 2016 only the final seniority was communicated. We have given objection. Prior to that, there is no final seniority was communicated. As specifically we mentioned.
Yes, he also, in fact, he also given recommendation basing on the 2011. In fact, come to page 35. Page 35, they also the reply given by the petitioners to the list 8/12/2011. Yes, page 35.
My learned friend has not only I am having 33 up to 33 only, madam. Pages. Even otherwise, as the lordship can see, let them submit an explanation by invert the order, madam, so that they will also give the reasons. This is only show cause notice. But ultimately, madam, merit should not be suffered. I am the meritor, I am the senior.
Yes, sir.
The red petitioner.
Yes, sir. For reasons.
GP Parliament recess. But in this, I have two instructions. Either they
Please. Item 20. Yes.
But in this, I have received the telephonic instruction ballot. Their cases were considered in 2018 itself for promotion to the post of corporate ballot. According to my statement,
I think,
because the petitions are also not touching the petition council ballot.
can you produce that proceedings?
Just inform me on phone documents.
Because now she also not in handicap. Can you verify?
Yes, sir, verify it.
It also will be satisfied. You could possibly also produce that so that even if she does have any communication, then place on record when close it. When do you want?
1 week.
$16.11. The account from DB for services to the GP for services to represent as per the instruction received by the business for the promoted in the year 2018. Takes time to
Item 45, A. Ajay Kumar, A. Srinivas Reddy.
The petition challenging the things. There is 13.16. The respondent setting an application providing complaint to government complaint appointment in video asking fairness the order of training of level.
Yes.
Level. The Deputy Manager Abdullah has issued this proceedings notice stating that in the initial case he was serving the report 7 years, 5 months and 17 days. Even after taking into consideration of relaxation 5 years, training starting the date of death of your husband, thus he was service underage and not eligible for employment under Behavior State. Even giving a claim additional monetary benefit in the of employment from the department is allowed. This proceeding is challenged by this restitution method. Rejecting the application and denying some type of appointment. This petitioner is the son of the employee driver. My father was working as a driver in the corporation and he died on 20th/6/1999. Subsequent to that, my mother has submitted an application on 29/8/2001. 29/8/2001, and as there was ban
was conducted driver. What was the driver?
Driver. As there was ban in the corporation on compassionate appointment, my application was not considered. Subsequently, 28/5/2004, I have submitted another representation. Last time, on 15/7/2013, I have submitted the exhibit P3 page number 14-15. But that was also not considered. Subsequently, on 25/7/2013, I submitted another application stating that the job to my son may be considered. The petitioner. Job to the petitioners may be considered. But the regional manager Adela response number 2 Miller rejected that application, stating that Miller as on date of death of employees, petitioner was underage. there is about 5 years, so even after considering margin of 5 years, not relaxation of 5 years, was unraised, that is 5 years, 7 months, 7 years, 5 months, and 17 days.
Yes.
This petition was filed in the year 2017. When cover judgment of the Honorable Court on relying judgment, criminal customer centers not this court. That would
Only
be
7 years old, then how can they have filed
this judgment may find it.
which judgment?
Number 3877 of 2017. This is the latest judgment given on 30th December 2022. This court mirrored. The facts are very similar to my case. In this case, the boy was 16 years. The applicant was petitioner was 16 years as on the date of application. And his mother was offered job. And due to some personal family issues, she did not offer job. She has not attended interview and she submitted an application stating that due to family requirement, she is unable to do job. Subsequently, she passed away. And the applicant has submitted an application. The petitioner submitted in this case submitted an application on 17/7/2017. This application was rejected. Stating that he was underage. In this court, the Lordship can see page number 5, para number 9. After considering various case laws of Honorable Court and this court directed the respondents to the Lordship can see para number 9. Taking into consideration of all the above record facts and circumstances, the order impugned number 7424 dated 17/7/2017 is satisfied and the petition is allowed. The respondents are directed to reconsider the case of the petition for compassion appointment, duly taking into consideration of the fact that admittedly as born with record the spouse of the deceased employee had applied for compassion appointment soon after the death of the employee. In past appropriate orders in accordance with 16 from the date of receipt of the copy, this order duly communicated in relation to the petition over the settlement. That what happened in the corporation order, there was a ban on compassion. Subsequently, in the year 2013, the ban was relaxed. It was similar. The ban was relaxed and ban was taken away, and the government has directed the corporation to consider the applications submitted by the dependents of the employees. See, after 2013, the respondents have received number of applications and the petitioner also submitted applications. Earlier, though she has submitted an application year 1999, 2001, 2004, and lastly 2013, and subsequent later on, the requesting the corporation to consider his son's candidature on 25/7/2013. Ban was there. As on that day, also ban was there. Subsequently to that, the ban was lifted. So, my submission is that, the facts of this case, squarely covers my case also. Your Lordship, allow my petition and pass orders.
Yes, the counter is fine. Yes.
Now the scheme is on the date of death within 5 years. 5 years concession is given. On the date of death, by the expiry of 5 years, on the date of death, it should be 18 years. That is the scheme. Now date of death is 20th June 1999.
Yes.
Date of birth is 3rd January 1997. In fact, the boy was about 2.5 years at the date of death. And after taking 5 years, he will be 7 and all. Now, Lordship kindly see the judgment. When we look into the judgment, this 22 judgment, Justice Nanda, Lordship kindly see the paragraphs. The case is totally different from the present case. Para number 8, date of the judgment, page number 4. This court opines that the plea of the respondent that the petitioner approves for compassionate appointment by filing an application on 23/9/2013 after 16 years from the date of death of his father is not a valid ground to reject or deny the benefits of compassionate appointment to petitioner. Admittedly, has gone on record and even as per the proceeding dated 17 of the second respondent hearing. And in particular, para 3, it is very clear that soon after the death of the deceased employee, petitioner's mother.
Yes.
Here the facts varies. There, the mother was not eligible because she was under height, and thereafter son was introduced. Here, mother's death occurred. Thereby, option has been given up to 16 years to the son. That is the major difference. This case does not apply. So, but however, the relief for compassionate appointment was not extended to her due to ban on the compassionate appointment. This court is of the firm view that the judgment relied upon by the counsel for the resolution has no relevance to the present issue and facts on the issue. Taking into consideration all the above record facts and circumstances, the order in June is set aside and the repetition is allowed.
What about mother? What if mother also filed application for compassionate appointment?
In the present case, mother filed. Mother was underweight, under height. So thereby she was disqualified. That as I have mentioned in my counter. It has come in my counter. That is para number.
Under height, para 5.
Para 5. This is admitted. There is no dispute about this. So she has come on record initially after the death of the husband. So she was not capable to go on with the job. Thereby, son was introduced. Now, Lordship may kindly see this judgment they cannot rely upon. And the earlier one more judgment they have filed, that is 2017 6 ALD 43.
Yes. 2013.
2017 6 ALD 43. Earlier occasion they have filed this judgment.
It's not there in report. What it says.
They are only relying upon the judgment, the present judgment of 22. In fact, they have supplied me the copy and supplied to the court also last feature. So if they are relying upon, I will proceed with.
It's not there and because I can't leave that.
Thereby
the that there is nothing. This is only judgment you are relying upon. If you want to quote he can quote any other judgment.
So this.
What about additional monetary benefit?
Additional monetary benefit we are offering. We are ready to pay it. They have mentioned in the counter also. We are ready to pay it. If they withdraw this, we will pay the additional money.
Died in the year 1999. Now my friend says they are ready to pay 1 lakh rupees.
Whatever it is, according to the policy, we will pay.
As a policy, even at the time was.
Maybe not if they
even at the time 2013 when rejection was there. 2017.
The amount was paid in the year 1999. The value of 1 lakh rupees was different totally.
Every organization has some certain circular, certain guidelines.
Even while rejecting the order 21 of the year 2016, they have not offered anything. After filing case and after 25 years, now they are coming with a
no. Just read that.
Ready to pay the amount.
Where is the rejection order?
Rejection order is a page number 7. 11.
Read last paragraph.
You may claim on us, but they have not paid. But I have not obtained.
Unless you claim, how will they see? However, you may claim for additional monetary benefit in your employment. It's mentioned. You are saying that you are not offered. They have offered in the.
No, even now also we are not claiming any monetary benefit. And the judgment, the only difference is she died in that case. Now, due to some family issues and also some health reasons, my mother has not come forward to do the job. In fact, it is admitted fact that my mother was under height.
No, what about the requisite qualifications? Whether the prisoner has got all requisite qualifications? That has
is a minor. Yes.
Now it's 19. Now it's 27 years. Now what is 19 years?
No, 23 years.
23 years.
Yes.
Now become major. Now present is become major.
Let him come with a fresh application. We will consider according to law. Whatever. Let him come with the fresh application.
Because now otherwise he is eligible, then
He possesses equal qualifications and also age.
right. Next. Order design. Next.
Item 52 and 53, Ramu N, GP for services is Abhay Kumar Sagar.
GP now we are also taking the color.
Amazing. Yes. What about Krishna Abhay Kumar Sagar? Krishna, not there. Item 52, it depends. It depends on that.
In my last presentation, this honorable court directed me to file the synopsis. So kindly grant me for mention.
Yes. How much time you require?
29.
He's seeing 1 week, you are seeking to him.
Copy, but I will also go. 1 week.
Provided you sir.
1 week from the mother.
18/11 Saturday.
24 last time. Other matters also process.
Perfect.
Item 49 also
Same.
For energy. 49 you are left with
23rd, 22nd, 29th. Request of Councilor Krishna in response.
GP perform services.
Easy.
Please stop the date next.
Saturday 18/11.
18/11.
Request of Councilor Krishna. Question 18. Right, but Japan, how size? Counter there, what is it? So many documents have been filed. Victor has filed 50 documents. You have filed 100 documents.
Of course, everything that should be have to transfer.
Item 57M Srikanth Reddy, G. Praveen Kumar, Singham Srinivasarao.
Paper?
Petitioner tried to call for the writ of certiorari, call for the records of the appellant courts. Second first respondent, my lords. In order passed in the appeal number 36 of the 22 of the 2015.
Respondent
is first respondent, my lords.
Who is the respondent?
Got the same. Third respondent counsel, Singham Srinivas.
What about 1 and 2?
Deputy Chief Labour Commissioner, my lords. That is the respondent number 1 and the Assistant Labour Commissioner is second.
DAG officer.
Yes.
Respondent was in the service mallards of the first petitioner bank mallards. From 16 June 1982 till passing of the order for dismissal dated 9 February 2010 mallards. Pursuant to the order of the disciplinary authority after holding a departmental inquiry against him under Regulation 6 of Bank of Maharashtra Officer Employees Disciplinary and Appeal Regulation Act 1976 mallards. For the acts of commission and omission with respect of the sanction and disbursing loan facility of Malegaon branch, Nasik region mallards. And the order of the dismissal dated 9 February 2010 of the disciplinary authority was confirmed by the order dated 24/9/2011 in an appeal dated 25 March 2010 prepared by the third respondent to the appellate authority and executive director. Here, my lord, the petitioner through letter dated 27/9/2014 informed the third respondent that his claim for payment of gratuity is not admissible in the term of the society section 44/6 A and section 46B second of payment of gratuity act 1972.
One second.
His claim is not admissible, my lord. But the reasons of the petitioner bank has suffered.
One second. Counter is not there.
I haven't filed a counter, my lords, we are ready for it.
Ready. What about respondent 1 and 2?
Gratuity amount which was passed by the first respondent and confirmed by the second, which was passed by the second respondent and confirmed by the appellant authority of the first respondent here in Malad. That amount has been paid by the bank, Malad. That amount has already been paid, Malad. So nothing
What survey?
Thing have been survived, Malad, but whatever the compliance is there, we have complied, Malad. But to put the you have filed this petition, Malad, to call for the record from the labor court and for the same, Malad. That is the reason we have preferred this appeal, Malad, because the bank has suffered 5 crores of loss, Malad, due to his negligence, Malad. And the departmental inquiry have been conducted, my lord, and disciplinary authority have been passed the orders, my lords, on 9 February 2010, and which was loss was occurred with the bank with these officers. That is on page number 45 and 46, my lord. 5 crores and now the bank has received loss, my lord. That's the reason we have.
You ready? Yes.
Yes, Mallards. After departmental inquiry, disciplinary inquiry, third respondent through letter dated 9/5/2014 requested the petitioner bank, Mallards, for payment of gratuity and encashment of leave. The petitioner bank through letter dated 22/5/2014 informed the third respondent that he is not entitled to encashment of privilege leave and as he was dismissed from services of the bank
and that the decision regarding the payment of gratuity will be communicated by the competent authority after ascertaining the loss suffered by the bank. The petitioner bank through letter dated 27/9/2014 informed the third respondent that his claim for payment of gratuity is not admissible in terms of section 4(6)(a) and 4 clause 6(b) second of Payment of Gratuity Act 1972. And his claim is not admissible for the reasons of the petitioner bank has suffered a huge loss of ₹5 crore. I am reading the page number 10, paragraph number 5. The third respondent filed PG application, payment of gratuity application number 38 of 2014 before the second respondent, praying for the payment of gratuity. The petitioner bank filed its reply to the application, explained the facts and the legal position of the and opposed the application of the third respondent. The second respondent passed final order on 5/6/2014, directing the bank to pay a sum of ₹5,23,850 within 30 days. The petitioner bank, being aggrieved by the said order dated 5/6/2015 of the second respondent, preferred appeal 36/42/2015 before the first respondent. The first respondent passed final order on the said appeal on 10 December 2016, confirming the order of the 5/6/2015 of the second respondent. So here, agreeing by these orders, my lords, we have preferred this writ petition, my lords.
What is irregularity?
Irregularities are at page number 10, paragraph number 6. My lords, may kindly permit me to read, my lords. The petitioner is challenging the said order dated 10 December 2016.
You can't read only affidavit. You read from the document what.
That is there at the disciplinary committee, my lords. That is at page number 37, my lords.
Affidavit content we can also everybody can read. Yes. So what is the irregularity?
Page 37 is the irregularities.
Yes.
Page number 37, my lords. Bank of Maharashtra HRM department, my lords. This is the disciplinary authority, my lords.
Yes.
Order dated 9 February 2010. The term loan aggregated to ₹484.78 lakhs and MKCC facilities aggregating to ₹212.15 lakhs to 56 borrowers. The term loan aggregated to 135.24 lakhs to borrowers. MKCC facility of ₹3 lakhs to Shri J.S. Pawar. His credit appraisal was defective and facts were concealed in order to extend undue accommodation to the borrowers. No post-sanction verification was done. And
no, your grievance is against the order passed by the first and second respondent.
He has not performed his duty. That is the reason that his duty
Don't
bank has suffered a loss, my lords.
You are reading from the discipline proceeding. There is separate proceeding. You are not on the point of proceeding. He is not, in fact, not on the. Your grievance is that the second respondent initially and first respondent subsequently, they have directed you to pay 5,20,850, whatever the gratuity is paying. They agreed by that. Show me what is irregularity in the orders passed by first respondent. You already suffered one order. The second order also you suffered. Now you are before the court challenging the order passed by first respondent. Just only confined to the irregularity committee why the court shall interpret with the first court order. That's all you can pay. Don't read all this.
Page number 27 is there. That is the disciplinary committee order passed by the Bank of Maharashtra on 24/9/2011. No post-sanction verification was done by him.
Tell me what.
My lord's, may invite my lord's attention to the order of the second respondent dated 5th June 2015.
Page.
Page 16. The order starts at page 16.
Yes.
My lords may come to internal page 2, my lords.
Yes.
My lords, line from last 10th, my lords, the last paragraph. The applicant submitted in his affidavit.
Yes. Yes.
My lord, may permit me to read, my lords.
Yes.
The applicant submitted in his affidavit that all agricultural loans or advances advanced by him during his tenure as manager at Malegaon, Nashik branch during period 2005-6 were all standard assets. The said standard assets hold good even on 30th September 2010, that is even after the termination of the applicant. The same fact was not disputed by the respondent bank during the course of proceedings at any point of time. Here I would like to pause for a moment. All the loans which I have given were against the collateral securities, and those are standard assets. This is not even denied by them even during the course of the proceedings. Even they accept that those are standard assets. Now, where is the question of negligence, Milords?
Yes.
Milords, the gratuity, the provisions of 4.6a attracts only in case of negligence or moral turpitude. One, and there should be a determination of the loss which has been suffered by the bank. Milords, here the bank themselves admit that all were standard assets. So there is no question of any negligence. If my lord may permit me to read. Further, the applicant submitted that respondent bank has recovered a sum of 75,75,000 in respect of 8 loans in one-time settlement. The sanction of one-time settlement in respect of 8 loan accounts is not by the applicant and is not responsible for the acts of sanctioning authority who has considered the one-time settlement. The respondent bank is till date had no confirmative quantum of loss. It is apparently seen that R1, that the disciplinary authority, as mentioned in the speaking order, as the bank is likely to jeopardize its interest to the tune of 8 crores. In the rejoinder filed by the respondent bank, the quantum of loss is estimated to be 5 crore. In R4, it is mentioned by the respondent bank that the percentage of one-time settlement is taken at 85.25%. And expected loss is mentioned at 7 crore. Therefore, the applicant emphatically stated that respondent bank has not spelled out the correct quantum of loss, whereas till now the respondent bank is emphasizing the financial loss only likely expected loss, which is imaginary only. Therefore, in absence of correct financial loss to the respondent bank at the time of dismissal of service from the bank, the forfeiture of gratuity payment is not tenable in terms of law. Milords, till date they have not quantified the amount which they alleged to be used by them. In fact, in the same similar parameters, in the same proceeding, they state 3 different amounts which they expect themselves to lose. In fact, if I may draw my lord's attention to the order of the first respondent.
Page 14. Page 14.
Order is dated 7th January 2017, Milords.
Page 14, please.
Yes, Milords. My lords will come to page 15, Milords.
Yes.
The first paragraph, upon examination of 4.6.
Yes.
Upon the examination of 4 subsection 6, it is found that gratuity payable to an employee may be forfeited wholly or partially to the extent of damage or loss caused to the employer. Further, upon careful examination and study of 4 subsection 6, it can be found that 4 subsection 6 of the Act is an imperative section which should not be read in isolation. It is very clear that the appellant is empowered for forfeiture of gratuity amount of the respondent to the extent of damage or loss caused by the respondent. Hence, it has also been found that damage or loss caused by the respondent has not been quantified by the appellant bank. It leaves an abundant scope of claiming damage or loss to a hypothetical extent. Further, the section 4 subsection 6 of the Act under question being imperative, it was a legal obligation on the part of the appellant to provide a natural justice to the respondent by way of inviting his representation upon the forfeiture. The natural justice and the right vested therein has not been exercised by the appellant. The appellant in a unilateral matter has forfeited the amount of gratuity of the respondent and has not applied any logic or reason thereto, along with the principles of natural justice. Milord, they proceed against me, Milord, without giving me an opportunity of being heard. They do not determine the quantum also, Milord. Also, there is no negligence or moral turpitude on my way of knowledge. All the loans which I have given, there was a collateral security and there were standard assets even on the date of my termination, which is after 4 years from the date which I have given the loan.
But
and today, as on date, Milords, entire amount is paid, so nothing survives in the writ as such, Milord.
Which amount?
The gratuity amount, Milord.
What about this order at page 24? But this proceedings of bank, you participate in the proceeding? Disciplinary proceedings against you? Charges are being framed. The disciplinary proceedings have taken place against you. Nine to 2010, the disciplinary proceedings in fact are initiated. Then against which you filed an appeal. Even that appeal was also disposed upon 24/9/2021.
The submission is nothing service without once they have paid me the entire gratuity amount. In fact, my lords, when I had given the loan, I had taken securities from them, and when one-time settlement was entered into, that was being done by my successor.
Yes.
Now they are trying to make me liable for the act of my successor, my lord.
When this the gratuity amount was paid to you after filing, before filing.
After filing this petition, my lords.
Compliance of the order of the passed by the honorable second respondent. You have paid one.
Once you are already paid, what remains?
Compliance of the order of the court, you have paid. Court officer.
Alright, but even if you now quash the orders, what is this?
And has suffered, and he also suffered a disciplinary orders.
Alright. We can take further any steps which are provided by law, but the once amount is already paid, now is only question of payment of gratuity. It is already admittedly already paid.
In fact, if I may draw my lord's attention to the interim order, my lords.
Yes.
Interim order reads pending further orders. Petitioner shall deposit 50% of the amount determined by the second respondent with the second respondent office within a period of 6 weeks. Means the amount was paid after the date. After filing the writ petition.
50% deposit. What about balance?
They paid me now. This was the interim order, my lords.
Yes.
Suppose that they have paid me the entire amount.
Interim order only says on 50%, then balance will stay. Are you to pay entire amount? And the interim order is only saying you have directed me to pay 50% deposit, 50%. Once you pay entire amount, nothing survives in the requisition.
That is my submission.
So all the amount we have paid, practically amount. That is at page number 22, money. Therefore, in view of the legal position and the facts of the constitution is release the gratuity amount as calculated above the applicant's hearing as performed the form are enclosed with the order within 30 days from the date of the receipt of the order. Order dated 5 June 2015.
Your facts. No.
Letter dated clearly 2015.
Now, my only submission is that the rate may be dismissed, my lords, since the entire amount has been paid and that is also been admitted by my learned friend.
What do you say? What do you say?
Your lordship, my lords, because bank has suffered a loss, my lords, of 65 crores. The reason we have preferred the separate purpose because the disciplinary authority also have taken the action against him.
There is only one aspect you just verify whether when this entire amount was paid. As per the order, it's only 50% was paid. Second respondent.
The exact date, my lords. Maybe they didn't want to pursue the matter.
It is there, my lords. Just now I have served to your lordship 5,23,850. And order is at page number 22. 5,23,850. Entire amount I have paid. Labor Commissioner Central Hyderabad.
My learned friend says so, my lords. Nothing survives in the rate.
Disciplinary committee has taken the action against the officer. They have challenged to the labor code and they have proceeded. Challenging the order of the honorable first respondent of the apparent authority of labor code.
Right. Once you have paid entire amount, what is
Yes, for complying the interim order, for complying the order of the honorable another authority of labor code. Within 30 days, time is also mentioned in the order. That is at page number 12.
what is the interim order? Interim order of this court?
Interim order is
20th July 2017, there was interim order.
July 2017. Pending further order, petitioner shall deposit 50% of the determined for the second respondent, the second respondent of within a period of 6 weeks.
Yes.
But not the 50% whole amount you have deposited, complying the order of the honorable second respondent.
The amount is in fact taken by
100%
released. No, amount is released or still with the.
That is my instruction, Milord, that he has received the amount.
It's very fine. Because only deposit that is still with the ACL, then probably it has to be further gone. Otherwise, suppose you already the amount is released, nothing there in further. You can give leave to take further recourse. Verify from the next week.
Lords, representing Deputy Solicitor General, Lords, for respondent Bhavan.
What
My
are-
apologies, my lords, for not being present on the matter.
What are the instructions?
My lords, it's between the petitioners and the respondent number 3.
Nothing. No, there is no role. No role for the central government.
No.
Can verify whether what happened is amount second respondent they have deposited 5,20,350 rupees already with the ACL too. Check with the second respondent whether the amount is deposited or still with them. It's this will continue, don't worry.
With the loss of kind permission, Millard.
Yes.
With the loss of kind permission, item 61, Millard.
Yes.
Millard, last occasion, the government taken time for filing counter. So far, they have not filed counter.
It will come up tomorrow. It will be there in this. Let us see. Who's for GP first?
Sir, this is 3 Raj. 2 weeks will be done.
They are seeking time again.
Last week is some other date.
18/11.
Pacham.
1 second, 1 second. 21/11. 21/11. Finally, no further than.
Pacham.